Wait, please, Lordship, with the consent of the other side, I beg to mention item number 27 of the daily list, Lordship. Lordship, the conducting council has some difficulty today. I pray that the matter may be adjourned for.
Adjourn.
Deep knowledge, Lordship.
May I please, Your Lordship? I beg to mention item number 28. My senior has some difficulties today, so the matter may be adjourned for the day. 28.
Compassionate drama. 1 minute. It's all about. देवव्रत तिवारी का जजमेंट की बेसिस में Where is your senior?
My lord,
Where is your senior?
he's in the PMLA court, my lord.
When he is coming back?
At 2 o'clock then, my lord. Otherwise, the matter may be fixed at 2 o'clock.
2 o'clock.
Please, my lord.
After 22 years.
May I please, Your Lordship?
May it please your lordship, item number 35. My lord, I'm sorry, my lord, I have mentioned it because lordship recollect that matter where limitation.
Simply ask you.
No, I have that, but I have will be person difficult or out of station. I have, your lordship has asked about limitation act, whether it applies.
That's
The
right.
temporary settler tenancy act 1971. We have researched that limitation act under the statute. In the statute, it has not been prescribed, but whether we can take the help of a limitation act where it doesn't prescribe, because the special act. 2-3 judgment of the Supreme Courts are there, my lord, in this connection. Whether 137.
In fact, if even though if you feel that this whatever the application you would file that is time barred, you can very well raise this objection before the trial.
No,
court.
I will just satisfy your lordship, my lord. Let it be listed. I have taken the concern on the other side. There are other issue where your lordship has asked me whether it's a procedural, the merit has not been decided.
Not at
That's what I will just point out. There is 2-3 points where the learned single judge has gone beyond that merit. So I just with your lordship permission, I'm sorry, my lord, I could not have filed an application yesterday.
When?
And my lord, 4th, 5th, any the next week? On 4th,
5th of June.
5th of, extremely sorry, my lord, for. There are few matters, my lord. I'll be out of session there. There's nothing, my lord. My juniors will come and they will 13 and 15 service has not been complete. That's why. Let them come and one matter. Yes. I'm deeply obliged, man. I'm deeply obliged.
May I please, Lordship? Lordship, I beg to mention item number 32, Lordship. Lordship expressing deep regret, Lordship, while filing this petition, we have committed some clerical mistakes, Lordship. So Lordship may allow us to withdraw the petition and file a fresh, Lordship.
Wants to withdraw this petition with liberty to file fresh. Dismiss with liberty as prayed for if occasion so arises.
I just now, Lordship.
May I please your lordship? In item number 42, my lord, we are going to file local nama on behalf of aspirant number 4, my lord. So finally, adjourn the matter for today. I have already taken consent, my lord. 42.
42. Where are you seeking time?
For respondent number 4, my lord.
What's the matter where you are seeking time?
We are going to file color now.
After a week,
Please, Your Lordship. I beg to mention item number 51 and 52, Your Lordship. I'm appearing on behalf of Mr. P. Mahanta. I'm praying for a short accommodation in the matter, Your Lordship.
hearing matter,
Hearing matter. Your Lordship.
adjourn.
Much obliged, Your Lordship. 15. May I please, Your Lordship, with the consent of the other side, I beg to mention item number 44, Lordship. Kindly, 4 weeks time may be given to file reply, Lordship. We need to seek further instructions.
Adjourn.
Much obliged, Lordship.
Right, praise the Lord. Item 58 has been shown to be mentioned. That's what I'm.
Let the board complete, then we'll hear.
May I plead, Your Lordship. Lordship, with the consent of other side, I beg to mention item number 48, Lordship. May I pray, Lordship, kindly take up the matter after 1 week, Lordship.
Have it after summer vacation. If a hearing matter, no.
Lordship, I'm for the appellant lordship. I have some anxiety, lordship, because my promotions are held up.
Why you have consented for that?
Lordship,
Hearing
I have
matters, certainly there is no urgency. Hearing
that's in the
matters
trouble of the respondent, lordship. Mr. AG is not there, your lordship. That's why, lordship.
is not necessary. We'll keep it in, after summer vacation.
Lordship, in
Yes.
that case, can I get a fixed date, your lordship? If it is not inconvenient.
Pending since 2017.
Lordship, it's okay. Lordship, I'll not trouble, lordship. Much obliged.
May please, Your Lordship. No, Lordship, I'd like to mention item number 46 and 47.
Yeah.
My Lord, with the consent of the other side, my Lord, they have filed the affidavit in opposition. You have to file a reply to it, my Lord. My Lord, further time may be required. They just filed it last week.
Let the number come.
My Lord.
There is any requirement of filing in rejoinder or not, we'll see.
Lordship, with the consent of the council for the appellant, I beg to mention item number 53 and 54, my lord. Kindly pass over the matter for the day on.
Yeah.
Lordship, I am for the.
All these hearing matters, if you are seeking adjournment, then they'll go after summer vacation. Summer vacation,
After that.
adjourn after summer vacation.
Wait, please, Your Lordship. Lordship, in item number 57, Lordship, the appellant has filed an affidavit, Lordship, as per the direction of the this honorable court, Lordship, that has been filed, Lordship. The record may be called for, Lordship. Obliged.
Orders item 1 and 2.
Lordship, in item number 1, earlier we took a step that was return answered. Lordship, here in this case, respondent number 2 is from Panbazar, Guwahati. In earlier occasion also, he didn't receive the notice, so we were allowed to publish the notice in newspaper, Lordship.
He is not residing in Guwahati.
He is residing in Guwahati, but he is not accepting, neither is appearing.
Accepting, where is the refusal?
Lordship, it is in the record, Lordship. And Lordship, what happened in item number 2, Earlier we took
But
steps.
the Lauzima court has directed you to take steps which you have not taken.
No, Lordship, in this case, not my Lordship, when we take steps on this note, in this address. He is not appearing, he's
10th of
not,
April case taken by the court on procedural of the previous 7-3 reveals that by the order, appellants were directed to take fresh steps on service of. However, a procedural of the office note reveals that the appellant has not yet taken fresh
he is
steps.
correct, Lordship. We have not taken fresh steps.
Why?
Look, because Lordship, earlier occasion, the notice was in item number 2. Lordship, pleased to see, we took step by publishing in newspaper also.
Send it. Item number 2 is altogether, send the registered AD and then if he is not accepting, then certainly will, if he is not accepting and refusal is there, service would be deemed to be complete.
Lordship, then I'll, today itself I'll take place.
Okay. 10 days time is granted to the council for the appellant to take fresh steps for service of notice upon the respondent number 1, 2, and 3 by registered post AD. On taking steps, let notices be made returnable to the aforesaid respondents within a period of 3 weeks thereafter. Yes,
Item 3.
Let me read your lordship. As per office note dated 24/5/2024, I wait for service report upon the respondent number 3, newly substituted respondent lordship. Deputy Commissioner.
Lordship, I have appeared today for the newly substituted respondent number
you are
3. Lordship.
appearing.
Yes, yes.
Yeah, Lanet, so and so put in appearance on behalf of the newly added respondent number 3. Newly substituted respondent number 3. Now, what do you want?
Lordship, already order has been complied with, Lordship.
Show us.
Yes.
What's the order of the court?
Lordship.
Page 11 in contempt case lordship. But they partly complied the order lordship.
You should handed over this
Yes.
land to the
GMD authority.
CEO, what in GMC. What about the this establishment of children park? The direction was
Because
to
they-
establish it in within 6 months.
Because Lordship, that authority only will construct it, Lordship. Because
Who is that authority?
GMD, they were not made a party in the earlier proceeding, Lordship.
In the earlier proceeding?
Yes, yes. Because,
And here they are party,
no, Lord.
made them party.
Lordship, yes. Lordship, kindly see the page number 14 lordship in the contempt petition. Roman 2 Lordship, that due eviction proceedings is under process under encroacher Sri Gopal Mandal against the unauthorized encroachment of a part of government land covered by Dag number 370. Lordship, we have to file our affidavit in reply against the report of the Deputy Commissioner in page number 108.
This land, Doug number 370,
Ah.
381 and 82. That land has been.
370
handed
has
over
not
to
been
the chief
evicted,
executive
Lordship.
officer.
Lordship, these two read petitions are already before. This one, Gopal Mandal and this Arjo Vidyapit higher secondary, they filed separate read petitions. Both are read petitions are.
What happened in that?
No.
No space there. So they have already handed over the land to the chief CEO.
Lordship, otherwise, kindly pass over for timing machinery is coming, Lordship.
Madam, you have to make party, otherwise how the direction would be complied with?
No,
CMC.
they have not complied, Lordship. The Kali Mandir constructed by the Gopal Mandal, Lordship, Dag number 370 has not been evicted, Lordship.
This possession of
We are-
the Act number 370 has been handed over.
Hmm.
So
We-
Officials are not party. This has been handed over now. It's
okay. This contempt petition is filed, Mr. So-and-so put an appearance on behalf of the substituted respondent number 3. It is submitted that the circle officer, Guwahati Revenue Office has already handed over the possession of the land measuring 5 bighas and 2 katha covered by Doug 370, 381, 382 of village Sahar, Ullubari, PT 3rd under Ullubari Moza to the Chief Executive Officer, Guwahati Municipal Metropolitan Development Authority for establishment of children park. We'll stop. But for establishment of children park, wide handing over report dated 13/12/2022. The copy of the said certificate is produced before us, which is taken on record. Full stop. This contempt petition is filed on behalf of the petitioner alleging that the order passed by this court on 26/8/2019 in WPC number PIL number 70/2018 has not been complied with. Full stop. White order dated 26/8/2019. This court issued a direction to the respondents in that petition to utilize the aforementioned land for the purpose of construction of children park. For the purpose of establishment of children park after removing encroachment from the said land. We'll stop. Since the possession of the land in question has already been handed over to the Chief Executive Officer, Guwahati Metropolitan Development Authority. We are. We deem it, and considering the fact that the authorities of the Guwahati Municipal Metropolitan Development Authority are neither party in the writ petition nor in this contempt petition. We are out of the view that the order passed by this court has substantially been complied with. However, if the petitioner has any grievance regarding non-establishment of the children park, he is free to pursue. They are the petitioner and they are free to pursue their cause before the Guwahati Municipal the Development of the Metropolitan Development Authority. With these observations, this contempt petition is disposed of.
Like,
Item 4 to 7.
Who is appearing for the petitioner in this 314?
Lordship.
Yeah.
Well, this is one of the instance, my lord, in the guise of the order passed by the Honorable Court in the PIL. The authority, my lord, taking steps for eviction of the persons, my lord, who are not residing in the, my lord, forest area. This is the one of the case, my lord. There is a stay order, my lord, restraint order passed by the court. Even that violating that, my lord, admittedly, they have evicted, my lord, some of them, my lord.
Fine.
But they, so far as the contention in the affidavit, what they have filed, there also it is, my lord, clear that the area under which is under our occupation are not the forest area.
Okay, fine. Because you this.
And secondly, they have also, my lord, annexed the that Kumarkhali Forest Reserve notification.
Yeah.
There specifically excludes the village of the petitioners. It doesn't fall within the.
That is their case that we are not evicting those persons who are in the, not in the reserve forest area.
Exactly, my lord.
That is their stand.
My lord.
That is their stand.
My lord,
That
they
we
are-
are not evicting those persons who are not in this reserve forest area.
No, not that, my lord.
That
They
is the-
said, my lord, the area in which, the area which is under our occupation, it is adjacent to the Kumarkhali Reserve Forest. And the query posed by the court, because we said it is a revenue assessed village where, my lord, the patta land as well as government land is there, and we have been residing in the government land, my lord, years
What,
together.
page number 138. Affidavit dated 5th of February 2024. By the Divisional Forest Officer Gopal Shara. Walpara.
One 38.
About additional 135 number.
Yes, my lord. This statement, my lord, at page 140, it goes against the action they have initiated against us. My lord. Rather in the
Just
yes, the first affidavit, the lordship may come, my lord.
This affidavit, para number 5. 5 to 2024.
Page 140, my lord.
140,
Yes,
please read this.
Yes. That the deponent begs to state that the impugn notice of eviction clearly states that eviction drives would be conducted only in the forest area under encroachment inside the Komarkhali Reserve Forest of Lakhipur Range, and there is no reference in the said notice to any government land or any revenue land. Therefore, the very fact that the petitioner have filed the present petition establishes the fact that they are in illegal occupation of forest land, since they would otherwise have no cause of any grievance. Now, if your lordship comes to the affidavit in opposition filed by them in the main one, they have, wherefrom they have evicted.
In
My lord,
reply to this affidavit, you have also filed an affidavit.
lordship,
One Nurul Hasan.
lordship.
Now, what is the reply to this para number 5?
That with regard to the statement made in paragraph 5 of the additional affidavit filed by the respondent number 3, the deponent begs to state that they are not given proper notice before the eviction was conducted. After the eviction, they have lost everything and have no other plots of land to take shelter. The wave severing pool was going on to save themselves. A few of them just temporary shelter under the broken piece of is clearly visible from the photograph, which annexes as so and so, so and so. They have given sketch. They have given sketch that
Mr. Sekia, there is a specific government that the notice only mentioned that encroachments inside the Komarkhali Reserve Forest and Lakhipur Range are to be removed. And these persons are not in that reserve forest area. They are not settled in this forest area. And in reply to this affidavit, you have not controverted that. That you are not in that area.
No, this is basically, my lord, after the filing the main affidavit, this affidavit has been filed, my lord, by.
Pursuant to the direction given by this court.
No, my lord, no, my lord.
Yes.
My lord, they have annexed certain documents, my lord. They have annexed certain documents.
22nd of January 2024, the court has given directed them to explain that whether this order dated 19/1/2024 is complied with or not.
Lordship.
In response to this, they have filed this affidavit.
My lord, subject to correction. My lord, after that, my lord, they have filed the affidavit in opposition, my lord.
Okay, fine.
Yes,
Read that.
that has been filed, my lord, on 1/2/2024.
After this 1/3/2024, okay, fine. Where is that?
1/2/2024, my lord, it
1/2/2024, this is of 5th of February, sir. Yeah, read
my lord, this,
page 102.
yes, my lord. Let me come to paragraph 5, my lord, page 103.
Yes.
That at the outset, it is most humbly submitted before this honorable court that the impugn eviction plan has been formulated in pursuance to the direction contained in judgment and order dated 5/9/2022, passed in PL number so and so by division bench of this honorable court. Further, taking note of the non-compliance of the aforesaid order dated 5/9/2022, a suo motu contempt case number so and so was also registered by the honorable court, which is pending and being monitored by directing to file compliance report. So and so that it is most humbly submitted that Goalpara Forest Division is a hotspot with regard to human-elephant conflict in this country, and this honorable court in the judgment and order dated 5/9/22 passed in PL number so and so has directed the district authorities to immediately take up eviction drive in reserve forest under Golpara Forest Division. That therefore the aforesaid eviction plan in Kumarkhala RF range is proposed in compliance of the aforesaid order of this honorable court after joint survey and verification by Revenue and Forest Authority of Golpara district. It is pertinent to mention that Kuspakari is an adjacent village Kumarkhali Reserve Forest and no individual having record of rights is being evicted in proposed eviction. We are all resident of this Kusapakri village.
Where they have admitted that these encroachers are of this village. Where they have admitted.
My lord,
Where they have admitted
Lordship.
that you are not in the forest area and you are the resident of the adjacent village.
My lord,
They have not admitted it. They have
my lord,
simply
we
mentioned
are-
the fact.
My lord, we are resident of the this
We ascertain this, sir.
the documents to that extent have been annexed, my lord, detailed documents, my lord, right from the, my lord, even the revenue receipt and the, my lord, the surveyed village.
That they are not removing you from that village.
So they have removed
You
me.
have encroached over, as per their allegation,
My
you
lord,
have
that-
encroached over the forest land, adjacent forest land, and they are removing you from them.
Lordship, my lord,
From
therefore,
there.
therefore, my lord, at the initial only I have said submitted, my lord, in the guise of the order passed by this honorable court, they are, my lord, they are removing, my lord, the persons who are not residing in the forest area, my lord. And even the notification, your lordship may kindly see, my lord.
Yes.
Whereas even if we go by the documents minors annexed to the petition minors, these are not title documents minors, even assuming they are correct. And we compared minors, only one person, name minor petitioner number 11, only his name is found in reflected in some kind of revenue record, which is also disputed minor. And all these are minors of revenue records of 2000, some revenue paying receipts of 2010, 2014 minors, and there are not any title documents are there. And the notice itself is general minors, and they have themselves come out that no, you cannot evict us because we are residing. Notice was general, that whoever is there come out. Notices was very general, the notice, my lord, is to page number 100
100.
of the petition. Hundred and one is vernacular, my lord, 100 is meaning translated. It was very specific in general notice. After issuing this notice, they have come out and said that no, don't evict us. Even in this reply affidavit, my lord, they said that they have been not served any notice. That itself implies that they are encroachers, my lord. Have did, my lord, they have resided in some pata lands or some government settlement lands, and they should not have come out. They should not have any anxiety, my lord. And that about the lordship sees, well, they are relying only on voter cards, ration cards.
Mr. Gogoi, just a minute. Mr. Saikia, see, if your clients or the petitioners in the other cases are asserting any right with regard to any land which doesn't fall within the reserve forest, then this PIL will not cover them.
Exactly.
Just a minute, just a minute. On one hand, they are saying that we want to clear the encroachment so as to free the elephant corridor, and which is the subject matter of the PIL. The direction is to clear the forest land. The notice is also to clear the reserve forest land. Now, when the eviction starts, your clients and some other petitions say that they are trying to evict us from our revenue village land. Now, there are already judgments of this court. Learned single judges passed a detailed judgment. Now, after the Supreme Court decision, there is a mechanism. If anybody in encroachment of revenue village land also, the eviction procedure will have to be totally different. So we will clarify that this order and these notices, etc., will remain confined strictly to reserve forest land. Now, beyond that, the writ court cannot do anything. You cannot remain in encroachment of reserve forest land. Question doesn't arise. And in clearing the reserve forest land, if they remove anybody from other revenue village, you have to avail your remedy. We can't do anything about it in a writ petition. That's the point.
No, my lord.
So,
Yes.
both of you
That's
that's the order we are.
I have approached this court. Also, have seen the notice, my lord. It under what law, what authority, nothing has been mentioned. It was hanged somewhere in another place.
Nothing is required to mention. Whatever be the law in this world, nobody can encroach upon reserve forest
Yes,
land.
exactly, my lord.
So that's the law.
That's the law.
No provision is
So, my lord,
required.
this, I have approached, my lord, the eviction, they have sought to, my lord, carry on 20th. I have approached this court on 19th. This court has restrained them from taking further action. And in the affidavit, your lordship will kindly see the audacity of the, my lord, officers, my lord, to ban upon the eviction of us, my lord. My lord,
So
That's-
that you have
that's a
to
separate
avail
issue.
your remedy.
but
We can't
I have,
comment.
my lord, the I is for restoration of possession, because when I have some approach,
Yes,
lordship, my lord, because I am, my lord. Because the day I had come to this honorable court, well, I was in the position, after the court's order, they have, even after the court's order, they have evicted me, so therefore, my lord,
for that, they
I
have
my
filed a
lord,
contempt petition. That is a separate issue. We'll answer that.
that is also my lord, pending, but
There's a different.
lordship, what the submission, lordship, may kindly see, my lord. On 19th,
Yeah.
on 19th, my lord, for the purpose of, my lord, this restoration, my lord, it's a separate argument, my lord, I'll submit, my lord, my lord. Now on 19th, the specific case of the respondent that the land which we are occupying is within the forest reserve. It is the council submission. my lord. Now the affidavit comes. The affidavit, they say it is this village is adjacent to the reserve forest, so it is not there.
Show us a line in this affidavit that the petitioners are the resident of the village, adjacent village. You show us a line in the affidavit.
Yes.
That all the
Yes,
petitioners are
Yes,
resident
yes,
of.
my lord, in my writ petition, my lord, from paragraph 2 to 3, my lord, I have recited. Paragraph 2 to 3 recited, my lord, how I have stated in paragraph 4, lordship may kindly see.
Yeah.
The petitioners gradually constructed their houses on the present plot of lands without any obstruction from any authority. It is pertinent to mention here that in the year 1985,
You're reading from your petition.
writ petition,
Fine.
this has not been denied.
Okay.
It is pertinent to mention here in that in the year 1985, deed and range demarcated the forest area and erected wire fencing. According to the said fencing, the petitioner's house were found outside the forest area. As such, the petitioner are continuously living on that land without any fear, and hence these poor people never thought to arrange any alternative plot of land for construction of house. But in 85, my lord, the forest department, they have demarcated, and the land under our occupation was outside the forest area. They similar is the affidavit, my lord, it goes well in tune of this statement, my lord. This has not been denied, and rather in the affidavit, it is going in that tune that the village where we are residing is adjacent to the reserve forest.
It is not there.
My lord, the paragraph
Page
3 of the petition, my lord.
102, my lord.
Paragraph 3 of the petition, my lord. They have admitted they have no documents, nothing,
So that's another thing.
my lord.
The only question is that you can't evict, the forest officials cannot evict any
The revenue, my lord, who have
who is residing in a revenue village.
evidence with documents, my lord. That is admitted, my lord. We are not touching them. It's their conduct itself they have come, my lord.
My lord, this my lord, this village is a revenue surveyed village, my lord. It contains, my lord, patta land as well as, my lord, government land. We are occupying in the government land in the said, my lord, village. The documents to that effect, my lord, have been annexed to the writ petition as well. And, my lord, in tune to the paragraph 4, what I have submitted, my lord, in paragraph 7 of the affidavit, what they said, my lord, Pushapakri is an adjacent village of Kumar Thali Reserve Forest. And the notification they have annexed.
Yes.
In the notification, your lordship will find which they have annexed, my lord, at page. It is from 126.
Yes.
This subsidy. 1911 kilo speaker.
Yeah.
The notification.
Of the year 1966.
Yes, my lord. There, your lordship may come to page 127.
Yeah.
The last, on the left side, my lord, they demarcated the bottommost, my lord. On the right hand side, my lord, they demarcated boundary from pillar number so-and-so to pillar number so-and-so, excluding the paddy field. There, thence to pillar number 46 at the bearing so-and-so at the distance of so-and-so, then to pillar number so-and-so at bearing so at a distance of so-and-so, excluding the Pursapakari village area. My lord, it isn't to that extent, it is, my lord, only what, though I have, my lord, clearly, my lord, said that we are residing in Pursapakari, that has not been denied. Now,
Pushapakari part 2.
if this, my lord, from the affidavit and the document, it is clear that this Pursapakari village is not within the forest range. So therefore, they will not carry out the, my lord, eviction in the Pursapakari village. That will, my lord, Sava, because we are not, we have categorically said we are not inside the reserve forest.
And what about these two other petitions, 7866 and 8223?
Well, these two petitions, one is, my lord, a rubber grower society, rubber growing society, which is a non-forest activity. On the basis of the direction of PI, when we tried to evict them, they came before the single judge, my lord. So it was tagged.
It was earlier, it was tagged.
Yes, my lord. And
By
another, my lord,
it was tagged.
both were tagged, my lord.
Last order is in relation to 3-1.
Yes, only this one, my lord. Last order was only regards to item 11.
And these two petitions were tagged.
My lord, these were tagged long, it's a considerable time, my lord. Perhaps 1 year has elapsed on it. 1 year or 8 months has elapsed.
So where is rubber? These are all individual petitioners in
Yes,
both
ma'am.
the writ petitions. Mr. Sikdar, you are appearing in item 10.
My lord,
What is your case in item 10?
my lord, here in this case, the petitioners, they are allowed to stay on the land, my lord, as a refugee of East Pakistan, my lord. In the year 1964, there is an order of the government.
In the forest plan,
Yes, my lord.
forest plan.
My lord, at that time, my lord, whether it is identified as a forest land or not, but they are allowed to stay on the land.
1966.
1964, my lord. The order is of 28 December 1964. They are allowed to stay on the land. They are staying on the land. And My lord, they have approached this on court because some notice was hung up in the locality and also the surveyor also visited their village. Therefore, on apprehension, they have approached, my lord. They are not evicted as on today, my lord.
You are residing in which
Yes,
village?
madam. We are residing.
Which
in-
village you are residing?
Yes, madam.
Sungat.
My lord, Rakkosini Jar is our place of residence. madam.
Which is?
Rakkosini Jar.
It is within the forest?
Yes, my lord. My lord, there is an affidavit by the respondent number 5.
The government. The cost of right to elephant can be put. Many of them are silver. कंटेम्प्ट प्रोसीडिंग में होगा उसमें होगा ना डीबी का ऑर्डर तो उसमें होगा 10/5 का 10/5 2024 एक है ना ओनली वन है ना उसमें ऑर्डर करो तो उनको ट्रैक इसमें रिक्विजिशन petition के लिए नहीं है ऑर्डर था 314 उसका 314 या इन दोनों में से ऑर्डर होगा तीनों को टैग
Is there any order tagging this WPC 314 of 2024 with the other two matters?
I was the one, on the last occasion, my lord, because the wrongfully, my lord, this matter, we had stated before the learned single judge that matter is ready for hearing, that is admission hearing, my lord. It was not admitted. Normally in course, my lord,
7866 and 8223.
My lord, it was also me, my lord, because we are restrained, my lord. Because of that restraint order,
But
I had mentioned this,
How these matters, when the court's order is not there,
my lord.
why these matters are tagged with this contempt?
My lord, because these also, my lord, pursuant to the, my lord, the directions.
Unless the court order is there, how can we, these matters can be taken? The court only ordered for taking 314/2024.
No, this, I have to check the order sheets, my lord. These were taken on court's order, my lord, because
No,
I
no,
was.
there is no order in this contempt at least.
Not, my lord, return no. But I can recall properly, my lord, these were taken, my lord. At my instance, my lord.
जिसका कंटेम्प्ट लगा है तो इसको और अगर उसके साथ तय की तो ये भी इसको ये कंटेम्प्ट तो किया ही मैंने उसको
Well,
Mr. Sigdar, why is writ petition, this, your writ petition is being tagged with this? Contempt?
My petition matter was reached.
Yes.
How it is tagged with this?
There was an order in the, in our petition.
Hmm.
To make a mention before the division bench for listing. Because we have also annex the order of the PI. Therefore, there is an order. Therefore,
File the, where is that file?
Which
but you made mention before division bench and then
It is
list.
submitted or the extending forest.
Well, there's an order of 24/8 minutes. 2023 minutes, by the this court itself, my lord, taking my lord. Single mention of it. But single mention, single mention, Nasile, yeah, TV does it 24. Well, there's an order of 24/8,
In the writ petition.
my lord, in the
Yes,
writ petition, my lord.
is there. Have you filed a reply in these petitions?
My lord, we have filed the affidavits, my lord.
In both the petitions?
Yes, my lord, both.
उनका consent लेना पड़ेगा
Mr. Since the order of the division bench is there to tag with this petitions with the, so we'll hear these petitions finally.
My lord, we filed the petition, my lord, enclosing the order of the PIL.
Oh, that's why only we have to, for the purpose of your rights, for adjudication of rights, we have to hear the petition here. You are ready, na? Hear both these petitions, we'll hear both these petitions along with this contempt petition. Argue it.
Here, my lord, in my case, my lord, the regular filed the deputy commissioner for my OTV, disclosing a fact that the reserved forest feature affected by the human and the relevant corridor conflict that has been identified. And that area not covered our village.
Okay, that's fine. We'll, on merits, if it is not covered under your village, we'll pass an order
My,
to consider this.
my,
You are ready for final arguments?
my,
Today?
and, yes, my, people, my, our case is that we have been allowed to stay in the land.
Oh, that,
We are staying-
whatever your case is, ultimately we have to decide it.
My lord. Lordship may kindly take up my writ petition.
8223.
Yes, 8223.
Yeah.
Annexer 1 is the general notice. General notice, my lord, defined in the area, and noticing that, and also the visit of the survey officer we have approached. And Annexer 2 is the allotment order of 1964, my lord, page 24. We have given the type copy as well as the photocopy. And my lord, Annexer 3, 1,
Just,
3, 2.
just.
উল্টা দিতে সেটা এটা নহয় বুলি কৈছে সেটেলমেন্ট এৰিয়া নহয় আপুনি য'ত আছে সেটেলমেন্ট এৰিয়া নহয় বুলি কৈছে
সেইটো লিখিছে, এইটো ভুল লিখিছে. We have rejected that one. We have highly counter to that.
Contradiction, no?
Contradiction.
Oh, assess. আপনার গোটেইকেইটা হেৰি নহয়, migrate নহয়। এই যিটো থাকিলে, গোটেইকেইটা migrate নহয়।
লিভাৰ ৰিলেটেড পাৰ্চন আছে, চিভিল কাষ্ট, চিভিল এৰিয়া।
সেইটো হয়।
কিন্তু চিভিল কাষ্ট আর চিভিল পার্সন মানে
আপোনাৰ যিটো নতুন সঁচা কথাটো কৈছে।
মিছা কথা কৈ হাৰি যাব পাৰিম এইটো আমি পিটিশনতে কিছু
What is your case, Mr. This 7866/2022? What is your case?
In this case, my lord, they are petitioners are registered society, my lord, Rubber Growers Association, my lord. They have cultivation only rubbers, my lord, there. But in Patta land, along with the khas land and also the, to some extent, some of the area of the forest land, they may not occupied. But by our cultivation, there is no trouble to the elephant, my lord. Not a single elephant, my lord, there, my lord, any problem, my lord.
So you are admitting that you are in.
We are
occupation of the
non-resident.
Forest land.
No, madam, we are non-resident there, madam. We have not resident. We are nearest person, all tribal people.
Maybe your cooperative society is in possession of some forest.
Yes,
land.
1 lakh people are engaged here.
Oh, fine.
And 250 crore And 11.50 crore
Then
has
get
been,
the land deforested from the central government.
yes, my lord.
It is not here we can't give this relief.
State government allowed them to cultivate there because all are lying
Whatever
vacant.
the state
place.
government has illegally allowed you to do.
1986.
Even 66.
Yes, my lord.
Can't tell.
Wildlife Protection Act.
Well, the Forest Conservation Act.
Forest conservation. Where is that, which is that
Section
provision
two, my
that
lord.
says
Section
no
2,
settlement given will have be valid?
well, that any section 2 sub 2 manner, that any forest land or any portion thereof may be used for not using anything contained in any other law for the time being manner. For instance, no state government or any other authority shall make except with prior approval of central government may order directing. I'm handing over.
And we're causing trouble to elephant also, my lord, because to 11.
Trouble or no trouble. Can't encroach or
Not encroaching, my lord.
just occupy.
Yes, occupying.
Occupy the forest land. That's all.
Conservation Act for nothing.
11.5 crore has been GST given by them petitioners.
Conservation of forest act.
Very impressive. Then go and tell the central government that we are paying so much of GST, so deforest this. land.
And permits also given, my lord. All India Rubber Growers Association,
Which
they
provision?
permit.
Well, Forest Conservation Act, section 2, my lords. Section Act of 1980.
Forest conservation. Yes.
No, 1980.
Section 2.
Restriction and derivation.
Subsection 2.
There's an explanation to also the non-forest activity, which includes my lord, cultivation of rubber. So non-forest activity.
But land was given when? Before 1981.
This land was allotted or allowed, you allowed to occupy this land since when?
84, my lord.
84.
84, 87, we started, my lord. In Patra lands also there, agriculture and caste land, and thereafter this, some extent, to some extent area vacant land. Some officers of the forest department told that, yes, these are lying vacant place, you can cultivate there. But keep the way of the elephant.
Only the oral permission.
Yes, my lord, oral.
Oral permission.
Otherwise, these lands are lying vacant land, my lord, not agree, not proper.
Forest land has to be vacant land.
Yes, my lord.
Forest land.
No.
Vacant
Has to be,
land,
but they put
forest land has to be vacant land.
only rubber plantations were there, but otherwise it is not cultivable for any crops, my lord. And keeping the corridor of the elephant also there, all in all way, my lord.
Orders have modified to the. If you want to put maybe order.
In your petition, there is no stay?
No.
No stay.
So, Mr. Sikdar, you are agreeing that the writ petition should be decided by the High Court Division Bench. If it goes against you, you will have no forum of appeal. That is only your concession. We will record it. Yes.
I'm leaving to.
Yeah.
I'm leaving to.
Close for orders.
My lord. Okay.
Item 12.
Fresh steps.
We needed time to take fresh steps in respect of respondent number 6, 8, 12, and 14, Lordship.
Then concept of the petitioner pays for an granted. Some more time to take fresh steps for service of notice upon the respondent number 6, 8, 12, 14, and 18. On taking such steps, that notices be issued to the above referred respondents who registered ready, returnable 6 weeks thereafter.
Much obliged.
Item 13 to 15.
May it please your lordship. Lordship, Mr. D Das had mentioned this item in the morning. Mr. D Das had mentioned this item in the morning. The service on the respondents is not complete.
6 and 8. Okay, as per the
Yes, 6 and 8.
report, service upon the service of notice upon the respondent number 6 to 8 has not been effected. Fresh notice through registered AD be issued to the respondent number 6 and 6 to 8 returnable transfer.
14 is merely tagged. It's an admitted appeal.
The Senior Council is preparing. Lordship,
Yeah.
So that's a tagged matter, my lords. I beg to appear in item 14 that has been tagged with 13 and 15. That's an admitted appeal.
That, this item number 13 is different, you mean to say that?
Yes, Lordship.
There's an earlier order of 12th of June, my lords, 2023, by which the predecessor bench had tagged my matter to 13 and 15. But it may continue, my lords. In my matter as an admitted appeal, it was admitted, my lord, on 30th of January 2023.
I'm in item number 13 and 15. Item number 14 is different. It's just
It's item number 14 is not related to this item
It's
number
only
13 and-
related. It's not against the same impugned order, my lord. But the issue is common to the extent this question of
Okay,
holding
then it's
exams.
okay, it will remain with this.
It will remain. There's no difficulty. No difficulty.
Yes, common issue.
Great.
Yes.
16.
Item 16.
Next, Mr. Lordship. Also, as part of office note dated, neither AD card dated 24/5/2024, neither AD card or answer notice received in respect of respondent number 1, Lordship.
Issue, the notice is issued to the respondent number 1.
Yes, also it was issued on
Has not been
26/4/24.
served- Has not been served till date. Let fresh notice registered daily returnable so.
Possible.
Fresh notice registered daily returnable 4 weeks.
Item 17.
Yeah, please, your lordship. So this IA has been filed in disposed of PIL 55 of 2017, your lordship.
Disposed of PIL.
Disposed of PIL. There was a direction, your lordship, to constitute the mental health review boards under the Mental Health Care Act by 1st of April 2023, your lordship. Since it was not functioning, your lordship, we approached the authority. And since there was no steps were taken, your lordship, we approached this honorable court. And after the intervention of this honorable court, your lordship, state has filed their affidavit. They are functioning now, your lordship.
They are functioning.
They are functioning. Only one aspect I would like to highlight, that the first minutes of the mental health review boards that are annexed with the affidavits, your lordship, they say funds are required for effective functioning. That is the only aspect. Otherwise, your lordship, the boards are functioning.
That will be a routine affair, lordship. It is not that fund will not be available. The work is going on, regularly meetings are going on, whatever steps, even much fund is also not required. Because they have to basically sensitize the existing staff. And the chairmans are the district judges, lordship. So if anything is required, these are routine mechanical and government work, lordship, that will be done. Otherwise, all the districts are covered. 5 boards are functioning, regular monitoring every month at the district level and every 3 months at the regional level. We have 5 boards in place, lordship, in Borpeta, Kamrup Metro, Kachar, Dibrugarh and Sonitpur, covering various
number
adjacent.
This IA is preferred by the petitioner in PIL number 55/2017, which was disposed of by this court while order dated 13/12/2022. Full stop. In the IA, it is mentioned that despite specific direction given by this court, the mental health review boards and committees either has not been constituted, and if constituted, are not functioning effectively. Full stop. Pursuant to the issuance of notice in the IA, the state has filed its response wherein it is asserted that the mental health review boards and the committees are now functional. However, a mention is made that proper funds are still not made available for functioning of the said boards and for effective functioning of the said boards and committees. Full stop. Today, learned Advocate General Mr. D. Sekia has submitted that so far is regarding the availability of funds is concerned, the state government is concerned about it and will make the funds available for effective functioning of the above referred boards and committees very soon. Yes.
In fact, Lordship, there is no specific allegation that funded.
Simply.
Yes, Lordship,
Very soon, in view of the assurance given by the learned Advocate General. We don't.
we have also already, there are accounts, everything is in place, Lordship.
Sufficient funds.
Funds will be made as and when required.
As
Already it is functioning. They have to not have
In a routine manner.
in a routine manner, Lordship.
Advocate General assured this court that the funds will be made available as and when required. Funds will be made available for effective functioning of the above referred boards and committees as and when required. We are of the view that no further order is required to pass in this. Yet the same is therefore disposed of. Yes.
The process of opening accounts, all this have completed, Lordship.
That we are all.
Yes, Lordship. Highly obliged, deeply obliged.
Item 18.
None is present on behalf of the petitioner today also. It is noticed that on earlier occasion, on 24/4/2024, also none was present. In such circumstances, we are of the opinion that the petitioner is not interested in pressing this petition, PIL petition, therefore the same is closed.
Item 19.
Lordship, there is an order passed on 25 May in PIL 66 2023, released
Yeah.
along with this PIL 5 2024. So this PIL may be listed with PIL 66.
Yeah, this affidavit you have filed,
Yeah, we already.
this autonomous hill council was supposed to file an affidavit, detailed affidavit.
Autonomous council?
No, sorry, NC Hill Autonomous
Yes.
Council.
Yes, no, they have, one copy I have, no? Respondent number 9, they have filed an affidavit. Yes. Page 308, no?
308.
8.
Yeah.
Vice Chair for affidavit. चार को
May I point out, Lordship?
Just a minute, just a minute. Who is appearing for the? Yeah.
They will the file.
Yes.
Sir, you have furnished a detail to whom you have dispersed the money.
Well, the NCL's Autonomous Council, the PWD department has given the money to them and they have disbursed the amount.
They have dispersed the amount.
Yes, yes.
Now this affidavit of this 22nd of April 2024.
Well,
It is by the revenue officer, revenue department, district of Dima, so
yes, 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 Pullo. It is under the NCL's Autonomous Council.
It is NC.
NC.
They have
Where is
filed
the council?
Well, Mr. RM Das, he appears, Pullo.
Yes,
My lord, last Monday, my lord, your lordship has passed an order to list this PIL along with PIL 66 or 23. So may I pray 66 or 23 is not listed today. So both the matter may be listed, my lord, on
sir, it is
first week
not,
of,
where is that order?
my lord, on last Monday.
But the other PIL, Lordship has passed the order.
Other PIL.
There is another PIL on the same subject, Pullo. In that, Lordship has directed to list this PIL along with that.
2024. Whose PIL now?
So
That PIL is for?
that PIL is, my lord, some
On the same issue.
embezzlement of fund, my lord.
Just along with the PIL number 66.
Of 2023. Can it be on 7th of June, my lord? Because
7th of June.
my lord, for admission, my lord.
Actually, for admission.
My lord.
Item 20.
Well, here we have taken steps on the respondent number 1, Lord. But
When?
but the Lordship has directed us to take steps. We have taken on 10th of May, Lord.
10th of May.
Lordship.
If 10th of May, we simply await.
It was awaited.
The notice.
It was awaited. Postal Talabana has been given, Lord. The report.
Rest karte.
Lordship, we'll take rest.
Notice upon the sole respondent has not been served till let fresh notice, AD, registered AD,
Lordship.
returnable 4 weeks.
Item 21.
One of this contempt case has been filed for alleged violation of order dated 28/8/2023. And page 19 is the operative part.
Issue notice, returnable.
Item 22.
Wait, please. So here, notice upon the respondent number 3 has not yet been served, my lord.
Respondent number 3, you are appearing?
I have before respondent number 1, 2 weeks time is required to file a objection against the delay petition.
Who is the respondent number 3?
3 is, my lord, the private respondent, my lord.
One is also private respondent.
Yes, my lord.
9
Two is the headmaster, 3 is the another teacher of the school, my lord.
delay is of 949 days.
Yes, my lord, 900.
As per the office report, notice upon the respondent number 3 will not be served. Yeah, इसमें await return of note. ये पहले भी कर दिया.
Office note dated 27/5, my lord.
एक बार और कर. Await return of respondent number 3 for 2 more weeks. In the meantime, counsel for the respondent number 1 and the respondent number 2 may file their response to the IE.
Highly obliged.
Obliged.
Item 23.
Lordship,
Delay of 107 days when notice was already issued, right? 107 days delay, madam. Notice was already.
Lordship, we need 3 weeks of time, Lordship,
For what?
to file an objection.
A serious objection or just for the sake of objection?
Serious objection, my Lordship. We need
And counsel with the respondent pays for him and the time to find objection to the IE. List of reports. Time paid for is granted.
For admission, item 24.
Cancellation of appointment cancellation order challenge cases.
Yes, sir.
May I please as a lordship? Lord, a very detailed and elaborate judgment has been passed by the Honorable Learned Single Judge, my lord. Lord, the Learned Single Judge has held, my lord, that the election process in which we did participate was not transparent, my lord. Was not
No
transparent.
selection process at all took place. This
No,
was
no.
the finding.
My lord, in fact, my lord, with all respect, my lord, what I am submitting, there was a selection process. That selection process was put into challenge in a writ petition before my lordships, before the single judge also, my lord. And there are orders passed by this honorable single judge also, my lord. My lord,
Then will, so para number, this, 20 of the judgment,
my lord, I have,
impugned judgment.
my lord.
You
My lord, we
give
have,
the answer to A, B, C, D,
I have, my lord,
up to this-
all annexures, my lord,
I, J, K,
my lord, my lord.
and even up to S, K, up to K, you give this answer.
My
and
lord,
get the-
no scope has been left unattended for us, my lord. But my lord, what has happened, my lord? We have found the certain, my lord, records that wherein, my lord, that the advertisement was floated school-wise. And my lord, in that advertisement, my lord, we did participate and we are also required to be file an additional affidavit, my lord. For certain, my lord. Huh. The vacancy position, my lord, and wherein, my lord, the post was earmarked. It will-
Yes, these findings are shown to be perverse. We just put an opinion principle.
So only simply because the advertisement was issued, there are other issues also. How
My
to
lord,
address
my lord.
those issues, sir?
My lord, one thing is there, my lord.
How
the
many persons have participated? What was the result? What was the,
Select list, my lord, was.
like this, nothing.
Select list is there, my lord. Select list is there. That select list was, my lord.
Ultimately, these are the finding of fact is the Reddit single is, right?
That's
After
why, my lord.
going through the
That's
record,
why, my lord, the document which we are going to put on record, my lord, are vital to adjudicate, my lord. My lord, a small, 10 days time is sufficient for us, my lord, to bring those, my lord, on record, my lord.
the Reddit single details dismiss the writ petition filed by the petitioners. While concluding that there are several material illegalities / irregularities in the recruitment process wherein the petitioners, wherein the appellants were selected and appointed. Full stop. The learned single judge has pointed out those illegalities, irregularities in para 20 of the impugned judgment. Full stop. Learned concept of the appellant has submitted that the appellants are in possession of some vital document which may have some impact. And therefore, he placed some time to produce these said documents on record. Good stop. Time plate for the list after 10 days.
Item 25.
Please, my lord. My lords, we are before your lordships. This organized lottery syndicates operating in the state.
Who is appearing for the state? You are? What step you are taking to curb all these illegal activities?
My lord, earlier one district only against the one district there is an order,
But
but
now,
other, but as per rules, my lord, lottery regulation rules, state can, my lord, give permission to allow the lottery, but
So as
with certain
whether-
conditions.
whether this permission is granted to these
No,
persons or not?
yes, the permission is granted or not, that I may be allowed to take it.
Issue notice. Mr. After you are appearing on behalf of whom?
1 to 52.
1 to 52.
These are all DC and SP.
So put in application on behalf of the respondent number 1 to 52. Let notice be issued to the other respondents returnable on through registered AD returnable on July की after summer vacation will fix it.
Obliged.
इसमें एक लिख लेना ऑर्डर है ना just a minute Mr. The issue raised in this PIL petition is regarding selling of lottery tickets both offline and online by the organizers of the lottery in the various districts of Assam in violation of the Lotteries Regulation Act 1998 and the Lottery Regulation Rules 2010. It is alleged in the petition that the state is not taking any action to curb the illegal activities of the private persons who are operating the said lottery business without authority of the law. Issue notice, then number 1, internal law.
Obliged.
Item 26.
भैया not having qualification क्या कर सकते हैं
My lord, the learned single judge has relied on a judgment delivered by another learned single judge, that is
Muktaram Dekha.
Muktaram Dekha's case, my lord. And in that Muktaram Dekha's case, my lord, this honorable court was pleased to help that, my lord, as the university do not have the NCT recognition. So therefore, my lord, the degree offered of the B.Ed degree offered by those universities, my lord, is invalid. In fact, my lord, the honorable apex court, my lord, which I have supplied a copy of the judgment on the last occasion, my lord. Honorable apex court in a judgment, my lord, has held that, my lord, once the university is controlled and monitored by the University Grants Commission, my lord. So therefore, a separate recognition from the NCT is not required, my lord.
CMJ University
Is a university, is a private university created by an institute by the state of Meghalaya, my lord. So therefore, my lord, they have a direct nexus with the, my lord, University Grants Commission. My lord, my lord.
You are appealing for,
I'm for private respondent number 4.
and you are appealing 1, 2, 3,
Yes, ma'am.
all.
Yes.
Issue notice, Mr. So and so put an appearance on behalf of the respondent number 1, 2, 3, and Mr. So and so is appearing on behalf of the respondent number 4. Service is therefore complete. Is this petition for final hearing in the month of after summer vacation?
My lord. Obliged, my lord.
Obliged.
Item 29.
My lord, the matter pertains to disciplinary proceeding resulting in a penalty of reduction in rank. The learned single judge has been pleased to dismiss. My lord. The matter has come up for the first time. Perhaps your lordships may like to issue notice.
Misbehaving with the mother.
Mal. That is the whole, that is the point, perhaps all concerned missed out. What would constitute misconduct?
Conduct if you are thrown out your mother from the house or as assaulted her, what remains?
The purely personal issues involved.
Purely personal issue, but ultimately she was put in the that guest house of the refinery.
Those are.
And she refused to go with you. You also refused to take her away. What else?
Actually, these issues are there, Malad, but the point involved in my humble submission would be, Malad, whether that would amount to misconduct under the rules.
You are misbehaving with your parents residing with you in the refinery itself. What remains there?
Malad, if your lordship so desires, Malad, I can place the relevant.
I think if you behave in an unbecoming. That is a risk. You are appealing for?
I'm for private.
I think my friend appears for
the refinery.
Private respondent, what is?
He has alleged malafide against.
I have alleged malafide is against some of the officers. It was at their instance, Malad, that
So if a officer of the refinery, if they,
in fact,
initiated the process for disciplinary proceedings on account of misconduct, then malafide.
no, some of the officers were involved in this whole process of my mother being taken away to the guest house and all those issues.
They they might have helped your mother since you are misbehaving with her. Admit parties are already represented. List for a hearing in due course.
Obliged.
Item 30.
Notice. You are referring for?
I'm appealing for higher education department, my lord, 1 and 2, restaurant 1 and 2.
1 and 2.
Yes, ma'am.
Mr. So-and-so put in appearance on behalf of the respondent number 1 and 2. Let notice be issued to the other respondents returnable on so and so.
We have filed an IA also
For what, sir?
praying for that this observation, which has a tendency of influencing the mind of the court below, may not be
I'll
now.
consider it at the time of application. At this interim stage, what observation you want?
Well,
What order you
that
want?
may not influence the minds of the other authorities.
Other?
Court below. The criminal court where the issue is pending.
Can't be, sir. That is also a separate proceeding.
No, that is why my grievance is. When this court will not look into and decide it, the matter is
In
pending.
fact, the court has gone in deep into the matter, but since the matter was pending before in the criminal court, therefore they have not interfered with it.
That's why,
Otherwise, so the prima facie opinion of the court is there that this is false one.
that is why my grievance is.
Will let the other party,
When a particular authority is looking into in its own jurisdiction,
Mr. Mahanta, let the other party make up. Will pass an order on interim. Issue notice of IA also.
Malad, connected appeal is also filed, my lord, in this regard. Arising out of the same judgment, my lord.
Same order, correct.
The petitioner in that petition has filed.
Yes, madam.
Read petitioner.
What's the number of that?
W 159/24.
That is registered.
Yes, my lord, that has been listed.
So and so list along with one writ appeal number 159 so and so.
159 of 2024.
Right.
Item 31.
Yeah.
May please your lordship, my lord, on earlier question, lordship, want to know, my lord, what is the function of the, my lord, this, my lord, gangman or track maintainer, my lord?
Yeah.
What is the function of the, my lord, track maintainer or, my lord, gangman, my lord? My lord, I have gone through some documents, my lord, if lordship allow me, my lord.
Yeah.
My lord, earlier he was working as, my lord, trolleyman, my lord. And
Trolleyman.
Yes, my lord. So now, my lord, he is, my lord, posted at, my lord, gang number 27, my lord, and assigned the work of the, my lord, this track maintainer, my lord.
Track maintenance.
Track maintainer, my lord.
So what's wrong in that?
3, my lord. My lord, this is, my lord, the completely different work of that of the, my lord, trolleyman, my lord. Because it's a work of the, like labor, my lord.
So labor means you mean to say that you are not supposed to do the work of labor?
My lord, this, my lord, petitioner, 52 years of, my lord, age, man. 52 years, my lord.
52 years, so what?
My lord,
So is there any this order of the railway, or is there any rule that the persons who are more than 52 or who attain the age of 52 years can't be posted as gangmen?
No, my lord, I have not found, but my lord,
Not found, then it's okay, sir.
earlier, my lord, and my lord, this petitioner also filed representation that was also not considered, my lord. Because that the order has been passed, my lord, without, my lord, giving any opportunity to me.
Yeah, before transferring, no opportunity is required to be given.
But my lord, though it is seemed to be transferred in the same place, my lord,
Yeah.
but my lord, my lord, work has been changed, my lord.
Work has been changed.
Earlier
Means,
from Parliament, yes, my lord.
you are supposed to do all type of works and nothing else. Okay.
My lord,
This,
my lord, I may be allowed to withdraw, my lord, only one, my lord, prayer. Yes, my lord, if your lordship going to dismiss it.
Yes, sir, certainly.
My lord,
You have
I will-
rightly anticipated that.
with the liberty to file representation, I will file a representation.
Again, representation, then you will come again that they have not decided the representation.
No, my lord, earlier I have
Again,
filed. In
nothing.
OA, my lord, my representation, I have filed on the basis of the representation, my lord, that was not
We
considered.
will not grant this liberty. No, then again you come with the contempt that they have not decided the
No, but some-
representation. And then if the representation decided fresh writ petition, they have decided it wrongly.
Since I have been,
start all
I have not been given any opportunity, my lord, regarding my allegation.
Either you withdraw it or we are going to pass an order on matter.
I am allowed to withdraw.
Now, wants to withdraw, dismiss, and withdraw.
Obliged.
Item 33.
Your Lordship, government was supposed to file an affidavit in bringing into the action taken in pursuant to the, my lord, inquiry report.
Yeah, Shiv Sagar.
Well, I need further some time, my lord. It has gone for the vetting. Can it be on, my lord, 7th? In the meantime, counting of the election will also take over, my lord. 7th Friday, my lord.
Council appearing for the
State, my lord.
state, there is some more time to file an additional affidavit as directed in terms of the order passed by this court on 20th of May 2024. List on 15th of June. List on 14th of June.
Item 34.
May I please? My lord, it's an appeal under section 260A of Income Tax Act. We proposed a substantial question of law at page number 10.
Page number 10, yes.
Lord, it was the case, my lord, the order was passed, my lord, things, my lord, the JV, my lord, they have not deducted tax, my lord, while making payments to its, my lord, constituent.
Substantial question. Having heard the concept of the petitioner, appellant, we are of the view that the following substantial portion of law are involved in this appeal. This item number, this page number 10, say 1, Roman 1, second, 1, 2, and 3. Admit issue notice returnable and so on.
Deeply obliged.
6 weeks.
I am obliged.
Item 36.
My lord, my senior is other court number 17. Time extend, my lord, next Friday.
Your senior is?
Pursitalam Mozumdar. Pursitalam Mozumdar.
Where is he?
Court number 17 in a matter.
Okay, we'll pass it over for some time. Okay, we'll pass it over for some time. We'll take up this matter after lunch for the time being.
Item 27.
May I please, your Lord?
Yes, I think so. Some petitions are also pending here.
Lordship.
Number,
Lordship, that is Lordship, 70-38, 2022, Lordship.
issue notice. Returnable on, you are referring?
I'm appearing for the health department.
I'm appearing for the Union of India here.
So all the respondents are represented. Yes. Mr. So and so put in a.
But one private respondent is there, my lord. Respondent number 5 is the private respondent.
Private respondent, who is the?
Lordship, that is the hospital, Lordship.
Yeah?
Hospital, Lordship, IV hospital.
Hospital
Who refused
takes the
to,
lead of that.
Lordship,
Try to make a hospital, unless the state government allows them, or the government allows
it's a
them.
formal
what the
practice,
hospital will do.
just a formal practice, Lordship.
Having heard the land council for the petitioner, we deem it appropriate to issue notice to the respondent number 1 to 4 only. The Mr. So and so put in appearance on behalf of the Union of India, and Mr. So and so put in appearance on behalf of the respondent number 1 and 2, and Mr. So and so is appearing on behalf of respondent number 3 and 4. Service is therefore complete. Counter to the writ petition be filed by the next date of hearing. Tag this writ petition along with.
Much obliged, Lordship.
Item 38.
May I appeal, Lordship? My lord, here appellant, my lord, has got the, my lord, highest score than the, my lord, private respondent number 4, 5, and 6. And my lord, 7, the private respondent number 4, 5, 6, and 7 have been selected and appointed. But the petitioner has been, my lord, deprived. Now, page, my lord, 139, Lordship will find the score obtained by the petitioner appellant, page 139.
You are basically you are challenging the select list.
Select list.
Dated
Select list, my lord, dated.
6/4/2013.
6/4/2013.
And the validity of that select list has already been upheld by this court.
But during the period of the pendency of the petition, list was valid.
Yeah,
The select list was valid during the pendency of the writ petition.
select list was
Valid.
valid,
Yes.
but sir, this.
Now, my lord, the impugned, my
The
lord,
learned single judge has dismissed your petition.
my lord.
In para number 4, in so far as select list dated so and so is concerned, the same was subject matter challenge to the writ petition number 1955/2013 by the judgment and order dated 15/9/2016. The writ petition was dismissed by upholding the select list dated 6/4/2013. In view of the above, writ petition is also dismissed. What's wrong in this order? Once the select list is already upheld,
Yes, now, lordship, my lord, page 190 is the, my lord, impugned order. Page 90, 190, my lord.
yeah, I'm going by
Yes.
reading the impugned order itself.
Yes. Now, this order, my lord, is conflicting to the, my lord, other order passed by this honorable court, by the same court, my lord. Now, lordship kindly see.
So this select list 6/4/2013, which is subject matter of challenge of the petition, has been upheld or not?
Select list was upheld.
Then?
Then, my lord, lordship kindly see page 182, the conflicting, my lord, judgment in an identical issue that has been allowed by the learned single judge. Page 182.
That, what is the order of the learned single judge? What was the order of the learned single judge?
Page 182, my lord, kindly see, my lord. That is
182.
another case arising out of the same select list. Page 182.
their lordship will find para 7 and 8, page 187. Para 7 and 8, my lord. Page 187. May I read, my lord, para 7?
Yeah.
From the affidavit of the director, it is discernible that the petitioner was called for appear in the interview for the post of subject teacher in Assamese in Dokhin so-and-so school. And in the interview, she secured 330 marks, higher than the respondent number 4, who secured 321.01 marks. And the fact that petitioner was called to appear in the interview would presuppose receipt of the application from the petitioner. If the petitioner had not applied, question of calling her to appear in the interview would not have arisen. That apart, the director has clarified that the respondent number 4 did not join the flowing or selective and appointment. That being the position, the Director of Secondary Education Assam is directed to consider the case of the petitioner for appointment as subject teacher in Assamese in Dokhin so-and-so school on the basis of her superior merit than the respondent number 4. And by accepting her candidature for the said post in the said school, this shall be done within a period of so-and-so. Now, identical issue, my lord. In that particular case, the petitioner got the, my lord, highest mark than the respondent number 4. That distribution was allowed. But in my case, my lord, that has been not considered. And my lord, admittedly, my lord, their reply given by the respondent authority in the RTI, page, my lord, 139, the appellant has secured more mark than the respondent, private respondent.
Sir, what is the order? This 1955/2013, where is that order? On 15/9/2016, where is this order, sir? 15/9/2016. This order passed in 1955/2013. Where is that order?
That order, my lord, at page 140, my lord, 140.
140, yeah. So the learned single judge has declined to grant this relief. A few new generation of qualified are now available for waiting committee in such circumstances, just and proper to bring this a logical conclusion, which in case has been achieved, therefore considered opinion that the select list process culminating in select list dated so and so is in substantial compliance of the court order dated 11/12/2008, and therefore this, and what happened to this order, sir?
That has been, my lord, attained the finality.
1955/2013
Yes.
of this 2016, that has attained finality.
Yes, that order has attained finality.
Remains in your petition, sir.
Now, my lord, our, my lord, case, my lord, the individual case, my lord, that has been decided by the honorable court. And lordship of one case has, my lord, has seen, my lord, the petition was allowed, who got the highest mark.
Okay. This writ appeal is, we are not going to interfere.
Now, admittedly, my lord, the appellant got the highest mark
Sort of it.
than the private respondent number 4, 5, and 6.
Taking into consideration all those facts, this learned single judge has observed that the selection process has to be bring to its logical conclusion, and That's fine,
But the learned, same single judge has
This-
allowed the another writ petition
That's wrong, kya kare hain?
on the point below the appellant secured the highest mark.
Can this writ petition, this writ appeal is filed by the petitioner being agreed with the order dated 3/1/2017 passed by the learned single judge in WPC number 3283/2013, whereby the writ petition filed by the appellant, petitioner appellant has been dismissed while observing that the select list dated 6/4/2013, comma, which has been challenged by the appellant in the writ petition has already been upheld by this court in WPC number 1955/2013, decided on 15/9/2016 and 16, full stop. Learned counsel for the appellant has frankly admitted that the order dated 15/9/2016 passed in WPC number 1955/2013 has attained finality. In such circumstances, we don't find any reason to interfere in this writ appeal. The same is therefore dismissed.
Item 39.
May I please your lordship, my senior is legs before another court. May kindly pass over the matter for the time being.
After lunch, then, after lunch.
If it is convenient for you, then it's okay. Otherwise, we'll adjourn the matter.
If your lordship will adjourn, my lord, then it will adjourn for minimum 4 weeks, my lord, but I am not suffering well, my lord. That's
4 weeks.
Much obliged.
Item 40.
But the same petitioner as in earlier, I think you'll actually. Dismissed. Item 18.
Okay, none is present on behalf of the petitioner. On 13/5/2024, also, no one was present on behalf of the petitioner. Full stop. The petitioner has also not filed affidavit pursuant to the pursuant to the time granted by this court on 13/3/2024. Stop. It seems that the petitioner is not interested in continuing with this petition. The same is therefore dismissed in default.
Item 41.
May I please lordship? Lordship, today I am going to file an additional affidavit, lordship. It is ready, during the course of the day, the matter will maybe come up with this additional affidavit, lordship.
What additional affidavit do you file in this petition? What additional affidavit you are filing? You are filing?
My lord, regarding maintainability or in this case, lordship.
Maintainability. There is no question of maintainability. Writ petition was maintained. Was very much heard on merits.
Lordship, we have annexed some vital points in this case, lordship.
Yeah.
In this affidavit, we have annexed some vital points, lord.
No, give us the affidavit.
Yeah, lord.
Yeah, what is this? What you have referred in this?
Lordship, point number 5.2, Lordship. While allotting land to small indigenous growers for special cultivation, preference should be given to indigenous youth coming from the families below poverty line, Lordship. And other indigenous educated unemployed youths, cooperative societies of the indigenous unemployed youths, Lordship. Lordship, point number 2 and 3, Lordship.
Yeah.
Lordship, the appellants were members of outletted Alpha organization, Lordship, who were surrendered before the Lordship. And they have formed a cooperative society, Lordship.
Right.
And the land were allotted to them, Lordship.
Yeah.
But never gave them position, Lordship.
Yes. We understand. That's all?
That's all.
Yeah. This writ appeal is filed by the appellant being agreed with the order dated 198/2000, order dated 28/3/2022, passed by the learned single judge in WPC number 879/2022. Full stop. Whereby the learned single judge has dismissed the writ petition filed by the appellant on the ground of inordinate delay of 21 years in approaching the court. So, full stop. The petitioner has filed the writ petition raising a grievance that he is you are the chairman of the cooperative society or what?
My lord, there are 5 members, Lordship.
That the, petition, कृषि PMM, the petitioner society has approached has filed a writ petition raising a grievance that in the year 2000, precisely on 2012-2020, the subdivisional land advisory committee Udalgiri wide resolution number 41 accorded approval relating to the recommendation for settlement of reserve government land measuring about 25 biga at Dug number 129 of village Rohini Khas, 25 biga at Dug number 475 at village Niz Baru Bazar, and 25 biga Dug 566 under Gadjiroda Gaon, so and so is to Muhammad Ghulam Hadi Chaudhary and others in Muhammad Chaudhary and others in total 4 sulfa, subject to the condition that they shall form a cooperative society and cooperative society. Full stop. It is contended that the cooperative societies was formed in the formed which having 50% at its members, but the possession of the land decided to be allotted to the appellants to the cooperative society has not been wide resolution number 41 dated 2012-2000 has not been handed over to them. Full stop. The learned single judge, having considered the facts and circumstances of the case, has dismissed the writ petition on the ground that the appellants, that the appellant society has approached this court with the inordinate delay of 21 years. Full stop. The learned single judge has also taken notice of a order passed by this court in writ petition number 1061/2001, whereby the court has directed the respondent authorities therein not to evict the petitioners of the said petition without following due procedure of law. The learned single judge has observed that apart from the delay, any order passed in this petition may affect the rights of the persons who have approached this court by way of filing a separate writ petition, and therefore no relief can be granted to the appellant society. Having heard the learned counsel for the parties, we don't find any case for interference in the impugned order passed by the learned single judge. The writ appeal is left.
Item 43.
Obliged, Your Lordship.
Validity of the order is under check. Validity of section
140 subsection 3 clause 4. And this matter is pending before the Supreme Court. This matter is not been decided.
that the same
Same issue,
validity
issue.
of the same provision under Chennai
Yes,
legal and council
Yes.
for the parties have submitted that by way of this writ petition, the validity of the provisions of subsection 3 of section 140 of the CGST Act 2017 is challenged. It is submitted that the the validity of this above referred provision is also subject, is also challenged before the Honorable Supreme Court in SLP number 3033/2018, and the same is pending consideration. Stop. In such circumstances, we deem it appropriate to defer the hearing of this petition till the decision of the Honorable Supreme Court is rendered in SLP number so and so so and so.
So yeah, clause Roman 4 of subsection 3 of one.
Yes,
Item 45.
But on behalf of respondent number 2, I have received the instructions today. I may be given 1 week time, or I file the affidavit.
Rich.
For respondent number 2.
Okay, Mr. Dinath, appearing for the respondent number 2, grace some time to file counter to the writ appeal. Time period for is granted. What?
Up to 10 days. I'll file.
After 10 days.
And in the meantime, the railways also may file their affidavit.
Yeah.
Railway may file their affidavit.
In this case, Lordship, let the government file the affidavit, Lordship, thereafter, Lordship, because
Let them.
After 10 days,
Yes, yes.
10 days.
can I prefer date after 10 days?
Specific date of the choice of the advocate.
Yes.
46 and 47.
Do you want time also? No. Only
Can
date.
we indicate some time also?
May I please, Your Lordship? Lordship, they have filed an affidavit in reply to our affidavit. My lord, I seek some time to file a reply to it, my lord.
You yourself has given this undertaking that I'll not ask for this leave and allow, salary and allowances. And now, and the learned single judge has already granted you the relief.
My lord,
What remains you want?
my lord,
You are asking something more?
no, my, I was asking only for my subsistence allowances during that period.
You already gave in writing that I'm not.
My lord, that was as desired by you, my lord. It was course, my lord. It was course upon me to give.
So that we can't do that, no.
My lord, because my lord, my writ appeal, my lord, I have very clearly, it has been in the, even in the affidavit which I have given.
Where is your undertaking?
My lord, at page 73, my lord.
Under the rules, he is entitled to subsistence allowance
My lord.
during the period of suspension.
But here, well, he took 1 month's EL only, and he went to Australia, and no information was given.
Facts are not in.
And Milord, he was under particular circumstances, he was suspended.
Allowance will include subsistence.
Yes, allowance included. Allowances include subsistence allowance.
My lord.
As desired, I hereby declare that I shall not claim pay and allowances for the period July 31st of July 31st, 2004 till date I am reinstated in the service on revocation of suspension order dated 29/3/2006. That's all.
My lord, this was compelled to the supervisor.
Compelled to, then you should have raised this when your writ petition was.
In the petition, I have raised it, madam.
Nothing way.
Man, otherwise, single judge has given me every, yes.
Everything.
Yes.
In fact, the learned single judge has given many things to you,
Yes, my lord.
which you are,
My lord,
at least for that period, dice are on that period in which you are remain absent and actually absent. That could not be given, but it's okay. Once
But,
they given and the state is happy, then it's okay. We are not concerned about that.
my lord.
Anything else?
My lord, that is what my writ appeal was only for the subsistence allowance, what my lord.
Well, the state has also filed the appeal, Milord. It is also listed. The writ appeal 248, Milord.
Status file will hear that state
Not-
appeal.
not-
This 2 बजे इसको लिखाएंगे. We'll dictate this order at.
Okay.
Yes.
I'm sorry that I could not come in time at item number 3, which has been disposed of by lordship. But that there has been an order from the division bench.
Item number?
Item number 3, madam.
Yeah.
Madam, this item may kindly be taken at 2 o'clock because there has been the recorded statement that the government has given an undertaking, they will enforce, they will evict the enforcers. Now, the ITA is occupying 2 acres of land of the children park. There has been no.
Children's park for the contaminant.
We have already passed an order, sir.
My lord, my prayer is that, your lordship, that ITA is occupying 2 acres of land. The High Court, the government has given an undertaking in the PIL that we will evict them. 50% they have carried out. That the rest of the 50% is not carried out. That is why, my lord, the government was taking time. At 2 o'clock, my lord, I will make
No,
the
we have
submission,
already passed
lordship,
the order, sir.
be kind enough.
Nobody was there, then we have already passed the order.
Now, lordship, be kind enough, just.
Madam was there.
But
We have
that,
already
because
passed
my friend has forgotten that to make that submission regarding 2 acres of land, my lord, that has been under occupation of the ITI. And that they have given another.
Mr. Saikya, liberty has been given to the petitioners to pursue the remedy, pursue the matter with the authority. Only the contempt part has been closed. That's all, nothing else. You still have the liberty.
The item 58, can it be taken up on Monday, Mayor? I would some difficulty.
Monday, which to be mentioned,
Mayor,
to be mentioned at
Monday.
Monday. Result किया हुआ है.
Monday.
Okay, to be mentioned in the, to be listed on Monday, in to be mentioned category.
Mayor.
My lord, the government has also filed an appeal against that order.
That will be decided on own terms. What is your relief?
So, my lord, my pleading is that before even this, I had given letters to the authority. That is at page 60, my lord.
Yeah.
Page 85.
85 or 60?
The page 85, man.
Yeah.
My lord, this is for correction of gradation list. Where, my lord, at the third paragraph, since the department have reinstated me after dropping departmental proceeding, so I kindly request you to keep my seniority intact, joining PWD on 30th June 2003, and provide me with a substantial allowance during my suspension period and salary admissible as per rule. I am praying for your consideration as my parents are currently suffering from ill health and all.
So you are, you are backtracked from your undertaking.
No, my
Simply
lord.
by making representation doesn't mean that you are entitled for that. Once you have given in writing, that I not claim anything, then you are not supposed.
But I was under commendable pressure, my lord.
Pressure, then you should not have done it.
My lord. My lord may see the situation that they have come and they should not also, they had asked me to give it on writing. That is why I had to give it, my lord. And that's why I've written as desired, my lord.
No, you chose, at that time you chose that reinstatement will get the reinstatement, then again will re-agitate the issue. And first of all,
My lord,
no, this can't be.
my lord, may I just show the timeline once, my lord, what has happened actually, my lord? Just the timeline once, my lord.
Yes.
Yes. My lord, what has,
The single thing is already dealt with.
yes,
In
my lord,
detail.
I was revoked, my suspension was revoked. I was, the BP was dropped, everything was dropped.
On the basis of your undertaking.
My lord, that is
You
there from,
requested that please reinstate me, don't give me anything. They said, okay.
my lord,
Then
that,
ultimately they passed this order, treating your services Dyson on
yes, my lord.
whole service. That Leonard Single judge interfered.
Interfered and said that the entire, this, that my seniority should be kept intact, my lord, and my date of joining.
That the Leonard Single judge is already.
Yes, my lord.
for that. Yes, be careful. This writ petition is filed. This writ appeal is filed by the petitioner being agreed with the order dated 18/11/2022, whereby while allowing the writ petition filed by the appellant, the learned single judge has directed the respondents that services of the appellant be treated to be in service and the service period of the appellant be taken from the date of initial appointment up to date when his service came or would came to an end as per law and accordingly. With the further observation that subject to the petitioner to all such benefits, he may be entitled. It is further clarified that the entire period of the appellant, which was forfeited as per the order impugned dated 21st of August 2018, the same is interfered with and the appellant would be constituted to be in new, same be interfered with. Full stop. It is to be, the defects of the case are that the petitioner, while working as an assistant engineer in bracket civil in the PWD department of the state of Rajasthan, sought for leave from 1/7/2004 to
State of Assam,
state of Assam from 1/7/2004 to 30th of July 2004. However, after his leave period was over, he has not joined. He has not joined his duties and overstayed the leave. Full stop. He returned back in the year 2006 and immediately was placed on placed under suspension by order dated 29/3/2006. Full stop. The department has also initiated disciplinary proceedings against the appellant under Rule 9 of the Assam Civil Services in bracket discipline and appeal bracket close rules 1964 read with Article 311 of the Constitution of India, primarily on the charges that he remained unauthorizedly absent from the aforesaid period. Full stop. In between on 18/6/2010, the appellant gave an undertaking on a non-judicial stamp paper to the effect that he will not claim pay and allowances for the period from 31st of July 2004 till his till his suspension is revoked. Full stop. Considering the same, the department, departmental proceedings against the initiated against the appellant were closed and he was reinstated in service. White order dated when he was reinstated?
White order dated 9th November 2012, annex page 70.
9th November 2012. Full stop. While reinstating the appellant, the respondents have passed an order whereby his services, his entire services were treated as disonon.
My lord, may I just,
Disonon. Yeah.
my lord, this order of disonon was after an writ petition filed in the High Court. Thereafter, they passed a fresh order. It was not in with the revocation order, my lord. That order, my lord,
That is, effect will be
21st August 2018 they passed.
disonon.
Disonon is reflected in on 9/12 order itself, it is reflected there. Halal. Disonon order.
The treated as disonon. The appellant approached this court by way of filing this petition challenging the notification dated 12/10/2016 with a prayer for providing him interest as seniority in the cadre and in the cadre. So when relief was granted by the respondents to the appellant, he filed the writ petition. The learned single judge has observed that the action of the respondents of treating the whole service of the appellant as disonon cannot be substantiated, cannot be sustained, and therefore the writ petition was allowed as noted earlier. Full stop. The appellant has filed this appeal claiming that he is entitled for subsistence allowance as per the law for the period he remained under suspension. Full stop. Having heard the learned concept of the petitioner and after taking into consideration the fact that the appellant has given undertaking before, gave an undertaking with the department. That is undertaking is at page
62, my lord.
62.
My lord. My lord, I apologize, my.
73.
73, my lord, 73.
73. Given undertaking to the department on 18th of June 2010 with the declaration that he shall not claim pay and allowances for the period from July 31st of July 2004 till his reinstatement, till the revocation of his order of suspension dated 29/3/2006. Full stop. in view of the fact that the appellant himself has himself has given writing for not claiming pay and allowances for the period he remained under suspension. We don't find any reason to direct the respondents to pay subsistence allowance to the appellant for the period he remained under suspension. Hence, no interference is called for. Hence, hence we don't find any
salary or reliance money. Baki will not be paid. Continue to pay. As a commission, is gas loan is the only way.
in view of the, we don't find any reason to grant the relief to the petitioner of subsistence allowance. We don't find any reason to issue direction to the respondents to pay subsistence allowance to the petitioner for the period he remained under suspension. Full stop. Hence, the writ appeal is dismissed. We made it clear that we make it clear that we have not we have not commented on the merits of the impugned judgment dated 18/11/2022 passed by the learned single judge on all other aspects. On all other aspects. Yes. That is writ appeal. We are issuing notices in this
I've already, notices have already been issued, my lord.
in this notices have already been issued. Have you filed any counter?
My lord, lordship may hear me, I can argue on them.
There is some problem, Mr.
My lord,
There is some problem in that. That's why only we you prepare your case better.
my lord.
Piece of full question.
Okay.
In fact, our appeal is prior to their appeal. Lordship. Lordship may fix a date.
Prepare your matter.
My lord.
Because prima facie we feel that this order of the learned single judge is somewhat
My
against
lord.
the service jurisprudence, sir.
My lord, the plea they may, if my lord is asked, may I have already, if my lord is asking the question, my lord. The plea they have taken is of FR 18, that is of non-dias. My lord, that for that the departmental proceeding has to be initiated. They drop the departmental proceeding.
Do some research,
My lord,
then come.
my lord.
This, just after 2 weeks.
Crossover meter, item 28.
May please the lordship. My lord, in this matter, my lord, the petitioner's father had expired on 1/7/2007, my lord. And he had applied on 6/8/2007. Though he was at that time, he was minor, my lord. And after 4 years, my lord, in the year 2011, he had approached this honorable court, my lord, on attaining majority, my lord.
And this honorable court, my lord, had directed that as per Ochikonjan's case, my lord, that may be considered. And accordingly, my lord, he had again filed an application, my lord, with the order of this honorable court, my lord, on attaining the age of 18 years, my lord. That was not considered after several part session, lord. Then he again, my lord, approved this honorable court, my lord, in the year 2021, my lord. On receiving the notice, my lord, then the, my lord, the district committee, my lord, considered his case, my lord. Then, my lord, it was, my lord, forwarded to the SLC, my lord. But, my lord, SLC had rejected, my lord, that it is late submission, my lord. Then the petitioner again approved this honorable court, my lord. And this honorable court held, my lord, that DLC did not recommend, my lord, only forwarded the case of the petitioner. So, my lord, in the year 2021, this honorable court remanded back the matter to the DLC, my lord. The DLC now, my lord, held that the case is that the petitioner was minor at the time of, my lord, consideration, my lord. Page number 31, my lord. It starts from page number 27, my lord. The last rejection, my lord. Page number 27.
That at that time when you moved the application, you were minor.
Yes, my lord.
That was the ground on the your application was rejected.
No, my lord. Rejected, my lord, that he was minor at the time of.
That's
Yes,
what we have.
regarding application not mentioned, my lord. That just he was a minor, my lord.
Yeah.
So, my lord, the petitioner, my lord, again approved this honorable court, my lord. And this honorable court, my lord, held on the basis of the two judgments of the honorable apex court, my lord. But, my lord, this honorable court, in a similar situation, my lord, relying on the my lord, Soid Khadim Hussain's case, my lord, I have, my lord, annexed with this petition, my lord, page number 44, my lord. Where, my lord, it was mentioned, my lord, that though the petitioner was minor at the time of, my lord, page number 44, my lord. I have annexed, my lord. The order of this honorable court, my lord, the single mention, page number 44, my lord. Page number 44, my lord. Page number 40.
Yeah.
My lord, page number 44 starts, my lord.
Yeah.
And relevant page number 47, my lord.
47.
Page number 47, my lord. It starts from 46, my lord, paragraph 6.
1 minute, 1 minute.
So, my lord, it starts from paragraph number 6, my lord, page number 46, my lord. The Soid Khadim Hussain judgment number 2006 9 SCC, my lord, page number 47 is the relevant paragraph, my lord. Where is the two paragraph, my lord. Paragraph number 6, in the instant case, the widow had applied for appointment within the specified period and without assigning any reason, the same was rejected. When the applicant submitted the application, he was 13 years old and the application was rejected after a period of 6 years, and that too without giving any reason. And the reason given by the authorities was incorrect, as at the time of rejection of the application, he must have crossed 18 years and he could have been very well considered for appointment. Of course, in the rules framed by the state, there is no specific provision as to what should be done in case the dependents are minors, and there would be any relaxation of age in case the dependents are minors, and there would be any relaxation of age in case they did not attain majority within the prescribed period for submitting the application. As the widow had submitted the application in time, the authorities should have considered her application. As 11 years have passed, she would not be in a position to join the government service. In our opinion, this is a fit case where the appellant should have been considered in her place for appointment. counsel for the state could not point out any other circumstances for which the appellant would be disentitled to be considered for appointment. In the peculiar facts and circumstances of this case, we direct the respondent authorities to consider the application of the appellant and give him appropriate appointment within a reasonable time, at least within a period of 3 years. My lord, then my lord, paragraph number 7, my lord, in the my lord coordinate judgment, my lord, may I read, my lord. In the matter before the Honorable Supreme Court, in Syed Khadim Hussain, the widow of the deceased therein submitted an application for compassionate appointment within the prescribed time, but without assigning any reason, it was rejected. Thereafter, the applicant submitted application when he was 13 years old, and the said application was rejected after a period of 6 years. That reason given authority is also incorrect in as much when the rejection was passed, the applicant was 18 years. In the aforesaid circumstances, the Honorable Supreme Court took the view that the applicant therein ought to have been considered for a compassionate appointment as per law, inasmuch as in the meantime, the widow of the deceased also became ineligible. Mr. S.S. Roy, learned junior government advocate for the respondents, point out in the instant case that there was such application made by the widow of the deceased, which was incorrectly rejected, nor was any application made by the petitioner as a minor immediately within the prescribed time, which required consideration after the attained majority, and as such proposition of law in Syed Khadim Hussain would be inapplicable. We are not expressing any view on the said submission. SSR and advocate to the respondent in a factor indicated different. So, my lord, the learned counsel for the petitioner refers another pronouncement of Shafiqul Islam. It is not relevant, my lord. Next, paragraph number 11, my lord. Mr. Roy, learned junior government advocate for the respondents, refers to judgment of the Honorable Supreme Court rendered in 2037 SCC to substantiate the contention that an application submitted by a minor for compassionate appointment attaining majority is untenable. Accordingly, reference made paragraph number so and so judgment, which are extracted as below. In support of the appeal, learned counsel for the appellant state submitted that the respondent's father died on so and so. The respondent applied for post so and so. The scheme itself provides the time period within which an application has been filed. The letter dated so and so does not confer any right to the respondent, as the scheme itself provided that the appointment will be made appointing authority concerned after clearance from the government of Manipur, Department of Personnel and Administrative Reforms. Admittedly, when no approval has been given by the department concerned, the mere issuance of the letter does not confer any right, particularly when the stipulation is contained in the scheme itself and there is a ban operating the respective. In response to the learned counsel for the respondents submitted that within the time period stipulated, application was filed in the year 1981, but there was no response, finding no other alternative. Respondent, who was a minor at the time of his father's death, applied afresh, and state cannot take plea that the benefit cannot be extended. Admittedly, respondent's father died before the office memorandum came into operation. In the memorandum, a time period is stipulated, since the scheme itself was not in operation. When the respondent's father died, the time of stipulation is provided in the scheme would not be strictly applicable to the case of the respondents. Anyone minor.
Yeah. Yeah.
So, my lord, in that case, my lord, there was no scheme, my lord. But in the case of the petitioner, my lord, the scheme is applicable, my lord, 1/6/2015, my lord. And my lord, since my lord, in this court judgment, my lord, the honorable court allowed this case, my lord, depending on the Syed Khadim Hussain judgment, my lord. But the petitioner's case rejected, my lord, on my lord, 2 cases, my lord. One is Sanjay Kumar, my lord. In Sanjay Kumar's case, my lord, what is, my lord, there that my lord. There was a direction, there was an observation, my lord, in paragraph number 3, my lord.
You attained majority in which year?
My lord, in the year 2011, my lord.
2011.
11, my lord. And he approves this honorable court in
Now,
that year.
what are you doing? Till attaining majority, what are you doing now?
Presently, my lord.
How many members in the family?
My lord, his wife, children, and his mother, my lord.
He is married now.
Married, my lord.
So during that period, without getting any job, he
Now he,
also, he got married also.
my lord, yes, my lord, as per information, my lord, he has opened a shop, my lord, near his house and
He has
running the
opened a
shop.
shop.
Yes, my lord, as per instruction, he has, my lord.
So now, even though if we offered him a service, then what about the shop?
My lord, that is, my lord,
What will happen to that shop?
my lord, as per law, my lord, if, as per provision, my lord, if he is entitled, my lord,
And
he
then,
prefer, my lord, better.
if you are running a shop, be happy with that shop.
Sir, my lord, a government job is, my lord, very secured, my lord.
Everybody is not getting
Secure, my
a government job. Shop business is also good.
My lord, the judgments, the
Since you survived for so long, why
My-
don't we interfere? It's ultimately, it's not a matter of right.
that is, my lord, the consideration is there, my lord. The right of consideration is there, no?
Yeah, right of consideration, they have considered it.
Wrongly.
Yes, maybe they have rejected it illegally, but ultimately now, if so many years have passed, almost,
My lord, the prayer is only for consideration, my lord, not for appointment, my lord. My lord, in my lord, in Sanjay Kumar's case, my lord, what was observed, my lord, that my lord, there cannot be reservation, my lord, of a post, my lord. That the father's post may not be reserved for the son, my lord, or the dependent, my lord, till he attain majority or the consideration of child. But in this case, my lord, there is no question of, my lord, reservation, because, my lord, the 1615, my lord, the OM, it provides a clause, my lord. Clause 15 is, my lord, if sufficient vacancies are not available in any particular office to accommodate the persons in the waiting list for compulsory appointment, it is open to the administrative department office to take up the matter with other department officers of the government to provide at an early appointment.
we are not on that point.
So, my lord,
We are on the point that since now you have survived for so many years,
yes,
then financial hardship is over.
my lord, in the
Ultimately, it is this scheme for compassionate appointment is to help the family who is in harness. And since your father died in 2007,
yes,
you are now in a business or whatever it may be, you are earning. And by
my lord, he is before this honorable court from 2011, my lord, continuously, and 2021, my lord, for a moment, my lord, 21 quarter, maybe, my lord, for a moment, my lord.
the application filed by the appellant seeking compassionate appointment was rejected by the respondent state. Full stop. Challenging the action of the state, the appellant has preferred writ petition before this court, which came to be dismissed by the learned single judge, by the impugned judgment dated 10/4/2024. Full stop. The learned single judge has dismissed the writ petition filed by the appellant, taking into consideration paragraph 7.5 of the judgment passed by the learned single judge in the state of West Bengal, passed by the Honorable Supreme Court in the state of West Bengal versus Debabrata Tiwari, reported in 2023, bracket close, SCC online, SC 219. Full stop. It is 219. Having heard the learned counsel for the appellant, and after going through the material available on record, we are of the view that it is not advisable to issue a direction to the respondents to provide appointment to the petitioner on compassionate ground after so many years, as the father of the appellant who was a government servant, died way back in the year 2007. Full stop. The appellant and his family has survived since 2007 without there being any government job. Hence, the learned single judge has rightly come to the conclusion that the case of the appellant on compassionate ground, the rightly held that any direction issued to the respondent to provide appointment to the appellant on compassionate ground after a period of about 17 years from the death of the government servant would not be in sync with the objective of the scheme for compassionate appointment. In view of the above discussion, we don't find any case for interference. Let appeal is dismissed.
Pass over meter 36.
Make please,
Since 2 years have passed,
Lordship.
new SMDC, the president of the new SMDC might have been selected or appointed. What remains in this petition?
Lordship, actually, I came before this honorable court. Actually, there was some delay, Lordship, because of getting the judgment, Lordships, and that delay was condoned, Lordship. But my respect to submission, Lordship, the committee of where the appellant was appointed by the.
Learned single judges found that in appointment of the SMDC, either to you or to the respondent, the procedure has not been followed. Therefore, the direction was issued to select a duly nominated person amongst the recommended names of the inspector school. That's all.
Lordship,
You are eligible again, you apply for that.
they should have to consider, as per notification, Lordship, the deputy commissioner duly selected with Lordship. So
We are not, since it's almost the order is of 2nd of December 2022.
Lordship.
And around more than 1.5 years have passed. The new president and the might have been already appointed.
Lordship,
So we
actually,
can't upset him.
Lordship, what has happened, Lordship, after the order was not online, and because of which there was a delay challenging the same.
We understand.
And
sir,
there was
but
a delay,
ultimately,
and which delay was
1.5
condoned by
years
this
has
honorable court, Lordship.
Sir, 1.5 years, that's why only we condone the delay, but we are not inclined to interfere.
And delay was pleased to condone, Lordship.
Yes, we have condoned the delay.
Lordship.
Our
And
bench has
I am
condoned
only
it.
on that, Lordship, whether the deputy commissioner have a power, Lordship, since the deputy commissioner, as per notification, page 48, Lordship, he have a ample, Lordship, that notification partial, all earlier notification, Lordship, was modified, Lordship, but the honorable single judge, Lordship, again, by virtue of the old notification, Lordship, relying on that, Lordship, cancelled by selection, Lordship.
Yes. Anything else?
No, Lordship, this one.
Okay. This appeal is, this writ appeal is filed by the appellant being agreed with the order dated 2nd of December 2022, passed by the learned single judge in writ petition number 3302/2022. Full stop. The dispute before the learned single judge was regarding appointment of president of the SMDC.
SMHS, CM,
SMDC, school management.
CMHS school. What is the name of this? CMHS?
Lordship, Chalmers had said that issue, CMHS,
SMDC.
Katli Chodala.
SMDC of CMHS.
President of SMDC of CMHS, CMHS school,
Katli Chodala.
Katlichera Alakandi. Full stop. The learned single judge has observed that appointment of the appellant as president of the SMDC concern, as well as the appointment of the writ petitioner on the same post was not in accordance with the guidelines, was not in accordance with the modified guidelines dated 24/6/2016, wherein the procedure for appointment of president of SMDC is provided. Full stop. The learned single judge has therefore issued a direction to the respondents to duly select and nominate a person concerned from amongst the recommended names by the inspector of the school for the post of president SMDC of the concern. For the post of president of SMDC of the concerned school. Having heard the learned concept of the petitioner and taking into consideration the fact that the learned single judge has issued a direction for holding fresh selection for president of SMDC concern, we don't find any case for interference. However, the appellant is free to apply for presidency of the SMDC in accordance with law. With these observations, this writ appeal is disposed of.
Supplementary list for orders, item 56.
Why it is listed for orders?
My lord, day before yesterday, my lord, your lordship asked to call them up, my lord, but they could not turn up. The matter was fixed for today because day after tomorrow, tomorrow is the date fixed before the tribunal.
On this schedule and. Casual workers, they wanted regularization, is it?
Yes, my lord, as per this.
Having worked for more than 240 days in one calendar year.
My lord,
They have not worked to 240.
No, that's right, that's your
let
case.
him complete, my lord, I'll make my submission.
What are the directions?
Yes, my lord.
They have simply directed you to retain them with you on the basis of last come, last go, first go principle.
Yes, exactly,
There's
my
no
lord.
question of regularization, nothing.
Exactly, my lord.
There's
I
no-
never paid
My
for
lord,
that.
they did not, Lordship may kindly see, this is the third round of litigation, my lord. Lordship may kindly see the annexure, my lord.
Mr. Consul, we are simply saying,
866, my lord.
what relief they have granted?
Because
please?
the Ghana Tribunal below has violated the section 22(3) of the Tribunal Act, my lord, Central Administrative Tribunal, wherein it says, my lord, evidence has to be adduced. My lord, may I kindly see section 22(3) of that.
Yes, yes.
Yes, my lord. That has been repeatedly, this is the third time, my lord, the Tribunal below did not exercise that power, my lord. And more so, they have relied on, my lord. Lordship may kindly come to 66, the order passed by this honorable court, my lord. That is order dated 22/10/21, passed in WPC number, my lord, 3386, my lord.
Just a minute.
Specifically, there was mention of a file, my lord. You know, 642 file I have with me, my lord. And they have projected a incomplete picture of that file, my lord. That file no way relates to the casual labor, my lord, temporary status. That is all about productivity linked bonus, my lord.
Yeah. Actually, I don't know.
I have the file with me.
We can check it. It is the scheme of the pension. If it has a particular number of days in a year. अगर we casual employee काम कर लेते हैं, it is for 3 years. To take it a right, get your right. Whether they have asked for that right or not, but वो right नहीं मांगते तो वो ये right अगर नहीं मांगते तो फिर क्या relief है? They should be the ones who should order नहीं पड़ा लेकिन मैं इस not select लगा कि discipline orders में आया था your clients are not aggrieved. There is a scheme of the central BSNL that
My lord,
at least minimum 240 days in a year.
I
They will be entitled
let
to
me place the
regularization.
fact, my lord. Just let me place it, my lord. What happened? In 2001, pursuant to the direction of the headquarters New Delhi BSNL, the names of 228 casualty entries have been sent to New Delhi. It's pending for regulation authorities. I've got no grievance at all. When the matter is pending that way, 228 persons' names pending in Delhi. At that time in 2007, what they have done from the list of 228, from 174 to 228, 52 persons, casual employee, they placed us under the contractor.
That is cancelled. They have gone to the.
Sir, please, let them.
Yes.
They placed us under the contractor. Rest 174 remained with the BSNL. Who filed representations, nothing happened. Then it came before the CAT, my lord. We made a prayer that although in page 74, there's a prayer has been quoted by the learned judge, my lord, here. But we made a prayer that our only prayer is, my lord, why not last come, first go principle is applied? Because in the list of 228, there are 150 persons. They are junior to us. Then why they placed under the contractor, my lord? That was the only grievance, my lord. Now, please have a look at page number 56 of this judgment, my lord, of this appeal. Lordship will find, my lord, the main contention of the appellant, of this applicant is placement under the contractor without following the last come first go. Even in the last judgment, my lord, passed by the CAT, my lord, in page number 86, it has been clearly mentioned, my lord. Just let me read this paragraph 86. Just one extra sentence we have not said, my lord. Page number 86, my lord.
And that we have,
That is,
noted.
I only want to say, my lord, I'm not praying for regulation, nothing else. Only since you have placed on the contractor, we came before the tribunal, my lord. Why not you follow the last come first go? Why you have chosen us only? Why should I go to the contractor? Because if I go to the contractor, productivity link bonus, yearly bonus, so many extra facilities, my lord. When I was under the BSNL, we used to receive. Now, why should I go to the contractor? We are getting the less money, my lord. They placed us. Next, my lord. So far, second contention is concerned. Lordship has seen, my lord, one of the grounds my learned friend has taken. The wrong file has been called. Lordship has seen, my lord. Wrong file has been called by the tribunal. Yes, A672. My lord. Just have a look at the order. Just have a look at the order. Last but 4 line, my lord.
File number A642.
Yes, that's the file, my lord. Lordship, honorable tribunal has called that file. In the appeal, what they've made, that in the judgment, a file has been recorded, called 672. It's a typographical mistake, or sometimes what MS my lordship dictates, my lord. Maybe they, my lord, instead of 4, they've written 6, my lord. See the order, my lord. Next, kindly just have a look at this 2 rejoinder. That particular file, we have given it before the tribunal. Tribunal has gone through this file. Then they have called for this, my lord. Kindly see. My lord, type portion I have given, but the untyped portion, my lord, page 15, kindly just have a look, my lord.
Yes, 642 in the.
Yes. Yes, page number 15, kindly come.
Yes.
Lordship has seen, my lord. Now come to the written part, because this is, I have typed it out. Please come to page number 8, my lord. Page number 8.
Yes.
Second paragraph, kindly, first paragraph, productivity link incentive for the year 2003-4, list number such and such, put up for consideration. Casual laborers, second paragraph, casual laborers who have worked for at least 240 days for each year for the 3 years, such and such, enter PLI. Bottom, lordship, kindly see. Out of 24, as per government notification, there are 78 number of casual laborers entitled for. Out of 24 has been paid PLI. 54 entitled for laborers can be paid. These 54 are we, my lord. And we have worked for 240 days in 2003, 2004, 2005, we have been paid PIL. Now in the tribunal, we said, we don't want also that PLI also don't want. Just we want to be back to the BSL, my lord. That's the only fear. So she was seen in my page 86, my lord. That's the only fear. We have not seen any degradation. Because from 2009, my lord, from 2009, these boys, my lord, running from pillar to post, my lord, legal battle with this mighty BSNL, my lord, can look at these people also. Now, out of 52, 5 persons died.
Mighty and poor.
Mighty poor, no, my not comparing, not comparing to this, my lord.
Poor BSNL.
Self-made, my lord, that is self-made. That's self-made, my lord, that is self-made. Now, out of 5 persons already died, 7 or 8 of the applicant had died, my lord. 7 or 8, my lord, they have left this place. Now remain 39. What's the difficulty, my lord? And now, my lord, kindly see what they have done. When the judgment has been passed by the tribunal, my lord, immediately they have started out, my lord, from the job. Now we are no longer in job. After working, fighting for 15 last years, that is the conduct of the respondents, my lord.
Until passing of the judgment by the tribunal, you were in job.
Yes, we were in job under the contractor. That's the fight we are having.
They cannot show a single evidence whether as to we have disengaged them. We have never disengaged them, my lord. This is absolutely wrong.
They themselves have withdrawn, my lord. And most of my lord, they did not make parties, these candidates, my lord, whom they say they are junior, my lord.
Yeah,
First of all, my lord, the persons whom they are saying their juniors have got this casual status, my lord, they have not made them party in the tribunal also.
you know, the
Also,
question,
my
they are
lord,
not asking, they are not asking that we should be allowed to march over them. They
because they
simply
do
say
not,
that will also be allowed to continue work with the BSNL, that's all.
Lordship, may I say, this will have an all India ramifications, my lord, all India, there will be reaction.
Why
my lord.
ramification? This judgment is not in RAM. This is in relation to these
My
applicants
lord,
only.
because they do not come and I understand, I have the sympathy with them, but they do not deserve as per the status. Lordship may kindly come to annexure 5, page 102, my lord.
You have sympathies with them, but they
But
don't deserve
technically-
sympathy or what?
My lord, because they have not worked the mandatory period of 200 days, so I have annexed, my lord.
The file is there, I have given the
Annexure
documents.
7, page 13. They cannot show any evidence before this honorable court that we have disengaged them. It is themselves, they
Okay,
withdraw from
we'll
the BSNL.
hear you an admission, but so far as stay is concerned, we are
Lordship,
not.
may kindly see annexure 8, how many days they have worked, my lord?
So far as regarding stay is there, we are not.
My lord, otherwise tomorrow is that day, they will come, the tribunal will be giving us an option saying that you either bring it for order of this honorable high court or you comply with the order.
Yes, so you
Lordship,
go
may kindly
and
see the
make
tip
submission.
case, my lord.
We don't find any case for stay.
Lordship, may kindly see annexure 5, my lord, for a moment.
Yes. Annexure 5,
Page 102, my lord.
yes.
I am directed to refer to this office letter so and so, wherein the scheme called casual labor grant temporary status regularization scheme was communicated. As per the said scheme, casual laborers who were engaged in 33, 85 and had completed 10 years of service were made eligible for regularization. Based on the above instructions were issued so and so, even though there is a complete ban on recruitment of casual laborers, it has come to light that many circles defying the orders had recruited casual laborers even after the ban orders. Since these casual laborers have completed 10 years of service, employees unions are pressing for the regularization of the remaining casual laborers who have recruited after 3385 and completed 10 years of service. This is the mandatory manner on the analogy of earlier decision of the Supreme Court on the subject. Under these circumstances, the matter has once again been examined and it has been decided by the Telecom Commission as a one-time measure on special consideration to further delegate powers to all the head of circles, metro districts, chief general managers, MPNL, New Delhi and Mumbai, and heads of administrative units to create posts of regular Mazdoor for regularization, the casual laborers grant of temporary status schemes and regularization scheme who have completed 10 or years of service as on 31/3/97. My lord, to the extent of the numbers indicated annexure A, my lord. Now, lordship, coming to annexure, my lord, 8, my lord, lordship, for a moment, annexure 8, page 140, 14, my lord. My lord, from 97 December, precisely, I have given this voucher also. They worked Vidya Tati for 90 days, Roopmala, 220 days. Forget of my lord, 80 days. They haven't not completed 10 years of as well, my lord. So how can they be eligible, my lord? And more so that I have the, my lord, file, 642 file. They have produced only portion of the file, my lord, just to miss it. Because this is no way linked to temporary status. This is a productivity link scheme. Lordship, may kindly.
No, yes.
Just on the basis of the, just on sympathetic ground, they were given this bonus, my lord, and they are now coming saying that we need this, my lord.
Yeah.
The note sheets, this page, my lord, this most important page, my lord. Letter dated 14/10/2024, my lord. They have not produced before this, and more so, my lord, this record, my lord, why you could not produce, my lord, the entire record? It was all along misplaced, my lord. We have strong doubts that this is the handiwork of some suspected.
Now it is straight out.
Lordship may kindly
Now the
see.
record is traced out.
Yes, yes, this is the entire record. I
So
have
how it is traced out when you have doubt that these people might have?
Because my lord, I have been told, my lord, some people came to the office, my lord, and some, it was missed all of a sudden where it was such, my lord, it was not there, and it was, this is not a matter of.
Yeah,
Then, my lord, that this is placed out, my lord.
suddenly somebody
No, it is.
thrown that
Yes,
record
it is,
there.
we strongly suspect that it is the handwork of these people only.
Suspect.
Yes,
You
my lord.
suspect
And
or you believe?
whatever Lordship mandate.
No, you suspect or you believe?
Suspect, believe, my lord.
Believe.
Believe.
So why you have not filed any case against?
Dangerous statement, but dangerous statement. Dangerous statement is a fact truth, my lord.
No, then if they.
And the departmental
Run
action
away
should be
with the
taken
record.
against the adding
You
officer.
should have filed a
Yes,
complaint with the police.
Yes, that they will shortly be taken, my lord. And because already one person is there who is the officer of our unit. So
He is hand in glove with them.
yes. Also, may kindly see the letter dated 14/10/2004, my lord.
Yes.
This is grant of productivity links incentive to staff of BSNL for the year 2003-4 on ad hoc basis. This is no way linked with, my lord, regularization, my lord. This says the matter of payment.
So regularization, no relief is granted. They have given up that relief. Regularization, no case of regularization is there.
We can engage them as a worker. Yes, they were.
Can engage them as those along with those workers who were retained with the BSNL. You can engage them.
Yes, then no, Lordship, I have to seek instruction then in that matter.
It is the only, this is what the instruction is, this is what the
Lordship,
direction is, nothing else. This is what the direction of the tribunal.
We said even we don't want PLI, but nothing we want.
Nothing doing.
Nothing. Just want to survive, my lord. We just want to breathe, my lord.
My lord, I have to take instruction, my lord. Lordship, may kindly see.
Yes.
This 14/10.
Again, you are ready to take them.
Yes,
They
yes,
are also
Lordship
ready
is
to
saying.
go. What's the problem then?
So I'll definitely seek instruction from my client and
on
let
the
your
cost
Lordship.
also.
My Lordship.
Also seek instruction on cost.
The petitioners have filed this writ petition being agreed with the order. What is the order of the
Tribunal.
order is? August, which date the improved order is?
Yes. Order is at my lord page 67, my lord, annex 3.
67, date of the order.
Date of the order, my
My
lord,
lord,
4th August 23.
4th of August 2023. The applicants has approached the tribunal with a prayer to issue a direction to regularize the services of the applicants forthwith, that is from the date when similarly situated casual employees were regularized by the BSNL. It is also prayed that the respondent authority be directed to place them directly under the BSNL authorities as casual laborers / mazdoor and treat them at par with those 174 casual employees till their services are regularized. It is also prayed that the respondent BSNL authorities be directed to pay productivity link incentive to the applicants. That is from 2005 / to the -2006 onwards, amounting to rupees 3,000 per annum. Full stop. During the course of arguments, the applicants have given up the prayer of regularization and only state that the BSNL be directed to allow them to work as casual laborers, public mazdoor with it. So that they would get equal pay for equal work as per their juniors. Full stop. The respondent, the tribunal has issued a direction to the respondents, BSNL authorities to put the applicants in bracket, to put the applicants in bracket 39 in numbers under BSNL directory to redress their grievances and mitigate their service economic distress. To redress their grievances with immediate effect within a period of 4 weeks. Full stop. Prima facie, we are of the view that the direction given by the tribunal are not liable to be interfered with. However, learned counsel for the applicant BSNL waste some time to complete his instruction that whether the BSNL is ready to implead, not to allow the respondents to work with the BSNL or not. He may complete his instructions by the next date of hearing. Put upon.
As your lordship pleases me.
As your lordship, because you have to complete your
Because
instructions.
tomorrow is the date, my lord, before the tribunal, my lord.
So put up tomorrow.
So tomorrow I have to go there, my lord. I'll place this order.
When this matter is to be listed.
Next week, lord.
The matter is before the tribunal day after tomorrow.
Day after tomorrow.
So you complete your instruction.
Tomorrow, let the matter which is tomorrow, my lord.
Put up tomorrow.
Briefly, your lordship.
My lord, case is over now. I just want to point out one thing. When we file a petition against the order of the tribunal, is it not necessary for us, my lord, to annex the OA also? Because there are annexures. When you make the argument, my lord, those annexures are very, very relevant. So when you file the writ petition against the order of the CAT, my lord, is it not necessary for us, my lord, to annex the writ petition, my lord, for other cases also, but not only for this case?
Is it necessary?
Because why I'm saying so? Entire
It
contention.
it is necessary.
Exactly, because he has not annexed the OA, and also my affidavit which I have given to your lordship, my lord. Number 2.
Now, he is seeking
No,
completing
I'm not from this case. I'm not from this case. But I feel, my lord, that should be annexed. It is convenient.
No, it is there.
That's what my answer
It
is.
is there.
Right.
He has provided all the documents which is relied upon before
Yes,
the,
my lord. Yes.
relied on in the trial
Yes.
court or before the lower court.
Yes, my published, my.
Briefly, your lordship. Come in your days.
You'll be able to complete your instructions by tomorrow.
My lord, I'll try my best, my lord.
You'll try me, if you are confident, then only take me, so otherwise.
Because
day
yes,
after tomorrow
because you have to hire up Delhi also, they have to communicate. my lord.
Monday.
So
Monday.
1 week time. my lord.
Monday.
Yes, ठीक.
Or the is 5th of June.
Deeply available.
5th of June. By that time you complete your instructions.
Deeply, right?
For admission, item 57.
But please, Lord. Pursuant to the order dated 27/5, I have filed the affidavit.
What happened?
There I have stated, my lord, that the post of president of the SMDC has not been filled up. No process has been undertaken to fill up the post.
Process has been undertaken.
No, my lord.
No process is
No, ma'am. Paragraph 4, my lord, I have stated.
political, the,
Lordship, my lord.
that is the question.
Lordship, the challenge was to my nomination as the president on the ground that I am serving in a school as an assistant teacher, and that I am also holding a post of vice president in another school. That was the, my lord.
That was the challenge, but ultimately the learned single judge has found that your earlier
Lordship.
appointment was cancelled on the ground that you are involved in political activities and therefore.
Exactly.
So that ground is wiped out or what?
My lord,
And
that
you have
no-
not challenged that order.
my lord, that notification does not bar me, my lord, for the political reason, my lord. The order is here, my lord. The other day I have, my lord, taken your lordship to that order. This order is at page 105.
She has accepted the order as well as the ground.
Allegations,
So this order dated 3rd of March 2018.
thereby it has only said that it leads to my lord, the controversies. Not that it is specifically said, but the allegation is not substantiated with regard to political my lord, activity, etc. my lord.
Whatever it may be, ultimately, if you are not found fit for holding this post in the year 2018, how you are fit now?
So, my lord, that time I was serving as a teacher, so that is one of the ground, my lord, for which my lord, it violates the government notification. But now I am not serving, so therefore, my lord,
So
they have
you were
nominated me.
appointed president of the school management committee in which school at that time?
My lord, at that time, my lord,
Alintangani Osmania Higher Secondary School.
this is the present school, my lord.
This
At, at that time, it was Dogaon AK High School
which
in 2016.
2016 you were appointed as president of,
Dogaon AK High School.
and this Dogaon and this Alitangani, how far they are?
It's nearby villages, my lord, nearby villages.
How can
Same area, my lord.
either you can be appointed a president of the SMBC, a particular school where you are residing. How can you go and get yourself elected as president of any of the school in the state of Assam?
My lord, it is the notification says about the person has to be local, my lord. The
Local. So
local.
you are local of which school?
My lord,
Area of which school?
my lord, the locality, my lord, that would be, my lord, with the block, my lord, the education block. So therefore, my lord, the block education officer is the, my lord, jurisdiction, my lord. Okay. And only that was not the ground, my lord, either in the earlier on 3-3, nor, my lord, the challenge in the present proceeding also, my lord.
Yes.
Since the
The
post is,
earlier 3/3/18 order is
my lord, at page 105, my lord.
105.
Lodge. Relevant lordship may come to, my lord, page 106. May I read, my lord? Well, the 5th paragraph, that has escaped the notice of the honorable single judge, my lord, with 5th paragraph, my lord.
Yeah.
Which starts with allegations against, my lord.
So you come to the order.
Lordship, my lord. At page 105.
Yeah.
Look.
Not this last 106 no operative portion.
Operative portion, my lord. Yes. My lord, it starts, my lord, page 23, my lord.
106.
106.
2000
Lordship.
2018.
106, my lord, page 106,
Last
Lordship, my lord.
order, after careful consideration.
Of all aspect and on perusal of all the facts and finding, and as stated above, and that Recruitment Ahmed has been given adequate opportunity of hearing, it is observed that Recruitment Ahmed does not fulfill the criteria and stipulated laid down in the guideline dated so-and-so and letter dated so-and-so issued by the government to constitute SMDC, hence claim of Recruitment Ahmed for the post of president of SMDC cannot be considered. Now, this is, my lord, on the two allegations were brought, my lord, here.
So it may be, sir. Once, what we are conveying you that once it is found by the concerned authorities that you are not entitled for appointment as president of SMDC as per the guidelines issued by the state government, and that whatever the observation or order has attained finality, you have not challenged that order, how can you claim again to be appointed as president of the SMDC? Your claim is rejected. You have not
Yes, yes.
challenged that.
Well, that was in respect of the Nagaon school and the ground
So
of
Nagaon
rejection.
school
Look.
president for the purpose of appointment of the president of the SMDC, the procedure is
Same.
applied equally in every school.
Yes.
So once there is a finding that you are not eligible for appointment as president of SMBC, then how again you can ask, no, not for this school, then I am eligible for that school.
I'm not, the ground of, my lord, ground for which, my lord, I have been declared ineligible is that I was serving in a
No,
school.
this is not the ground, sir.
Yes, my lord, that is the
No,
ground.
this is not the ground, sir.
Lordship.
Only it is
Political
stated.
worker.
Yes, my lord.
Here, he
Yeah, you have admitted it.
he has admitted.
May I read the, my lord, order, my lord, the portion, my lord, in the paragraph 106, my lord. First is the education that has been substantiated. So far as the political career is concerned, my lord, in fifth paragraph, it has been said, allegation against Recruitment Ahmed, although not substantiated, an incident of protest that followed makes him vulnerable to suspicion and doubt, and hence his reputation, though cannot be questioned, but has invited controversies. This is with regard to my political activity or career, my lord. And what is the, my lord, political career as per the notification is that the person should not be contesting in any, my lord, election for the panchayat.
Mr. Council, we are not on that point. What we are saying that once there is a decision rightly or wrongly that you are not eligible to be appointed as president of the SMDC, and that order has attained finality, you have not challenged that. Then how can you claim, sir, until and unless that order is reversed, that finding is reversed, how can you claim again I be appointed as president of the SMDC, sir?
That was on the ground that I was serving in that
It's a
school.
ground or-
That was, my lord, substantiated.
That is not there, sir, in the order. It is not reflected from this order.
But this-
On account of this, because you are serving as a teacher, you are not eligible for appointment. That
Yes,
is
ma-
not the ground here.
My lord, this, if I'm permitted to, my lord, read this. my
It
lord,
is
here.
based on 3-4 grounds.
Lordship, my lord.
That since you are involved in political activities, it is not advisable for to appoint you as a president of the SMDC. You may invite controversies. This was the one reason.
That is, my lord,
And second reason was that you were working as a teacher.
teacher, my lord. Yes,
There were two reasons.
Lordship, my lord.
And two reasons, if that order is attained finality, and even though if one of the reason that now you are not working as a teacher is not more or not surviving, then also on the other ground you are not entitled for that. And therefore the learned single says rightly held that once it is observed that you are not entitled for appointment or eligible for appointment as a president of SMGC.
Because of the political career, the honorable single judge has said, my lord. But the
maybe-
notification, your lordship will kindly see why I'm saying, my lord, this order 3-3, it says it invites controversies. But so far as the notification is concerned, my lord, one has to, my lord, stand in an election, my lord, from the panchayat to, my lord, parliamentary, my lord, constituency. That is, that person should not be, my lord, appointed as a, my lord, president of the school managing committee.
There is
And
a, there
so
is a-
mayor-
there is a-
mayor-
there is
mayor-
a reason for making such provision because If a person affiliated with a particular party is appointed as the president of the school management committee, it may lead to many controversies. He may.
In fact, the authority.
May use his authority for fetching the votes or whatever it may be.
In fact, subsequently in 2019, I was again appointed as a vice president of a school, of a managing committee of a school by the government
Of another
themselves.
school.
In 2019.
So you are eligible for appointment as president, vice president, any of the school of any of state of
No,
Assam.
in the same school, Doggaon school, my lord, because I have resigned from the post, my lord. After this, my lord, I have resigned from the post, and thereafter I have been, my lord, appointed as a vice president. My lord.
Yes.
My lord, in 2018, my lord, after this order, I have resigned from the post, and thereafter, my lord, I was appointed, my lord, as a vice president of Doggaon school, my lord, that I had been continuing, my lord. And thereafter, my lord, I have been recommended for this, my lord, particular school, my lord, for the post of president, my lord.
Yes.
And because this order, my lord, does not, my lord, bars me because of my political, my lord, career, the observation, my lord, of the honorable single just perhaps, my lord, needs, my lord, interference, my lord. That is my, my lord, submission. Otherwise, my lord, for the all the time to come, my lord, I'll not be able to do that, my lord. Although I did not violate the terms of the, my lord, guideline, my lord. The lordship may kindly have a look to the guideline, my lord, which I have annexed at page 57.
Yes.
Page 57 is the guidelines, my lord, I have annexed.
Yeah.
That's right. The last paragraph, my lord. Under the circumstances, I will revamp the existing SMDC. Following criteria will be enforced to become a president, vice president of the SMDC. 1, 2, 3, lordship may skip the 4. Any person who have contested any election of panchayat level, parliament, or assembly election in last 20 years should not be considered
Thereafter,
for
there
the
is a
post.
clarification.
My lord?
Thereafter, there is a clarification also. In these guidelines, there is a clarification also.
My lord, in 710, my lord.
24th of June 2016, thereafter there is another clarification is there.
My lord, that is 7/12/2016, my lord, further notification at page, my lord, 104.
Yeah. It says what?
It says, my lord, regarding serving teacher, my lord, 104, my lord.
No, sir, the notification.
And holding 2 posts simultaneously.
Learned single judge observed that the notification dated 24/6/2016 read with the modification made their own wide notification 24/7/2021. Where is that notification dated 24/7/2021?
Page 27/10, my lord, 21, page 61.
24/7/2021.
Perhaps 7 is wrongly, my lord.
In para number 15 of the judgment.
Got you, my lord.
Mr. Saikia. With a lot of reservation, we are just pointing it out. You are probably not hitting the nail on the head and not even following the response coming from my lord, the Honorable Chief Justice. You can only have a case if you can show that after the previous rejection, new guidelines have come in, which have changed, and therefore you are entitled to a fresh consideration. Otherwise, the learned single judge has held that earlier round, as per the existing guidelines of 2016, you have been held to be not eligible, and that order you have not challenged. So what is the point in again wrecking it up again and again and again? That's the correct position. That's a view taken by the learned single judge. All you can get is a fresh consideration if new guidelines have come. In that case, if the order is implemented and the process is concluded, you will be eligible as per the new guidelines if the guidelines have changed. That's the only point to be argued here. What else are you arguing since last 20 minutes? You are arguing against settled principles of law.
What I'm
sorry.
trying to impress upon your lordship, my lord, the notification lays down, my lord, several criteria. I highlighted at that time one of the criteria, so my nomination
Mr.
was
Saikia,
cancelled.
the part you have read,
Lordship.
you missed out the two paragraphs above that. Please come to that, 104. You have not read that. 106.
106. Yes, ma'am.
You have started from allegations against
Yes, ma'am.
Ruku.
During,
Two paragraphs above.
my lord, during that period in the year 2016, it is clearly understood from all
Paragraph from Rukunuddin Ahmed is said to be an active.
political worker. Recruitment Ahmed in his own statement on 17/1/2018 stated that his candidature has been supported support of
And the support of
AUDF and BJP public and
Candidature means what? Candidature for some
my lord,
election.
to this post, my lord, not my lord, this particular post, my lord.
But then you have admitted it.
To this post, my lord,
You have not challenged this order.
lordship, my lord.
That's over then. Nothing can be done. A view has been taken by the learned single judge.
My lord, this is for the post, but the notification, my lord, regarding, my lord, contesting an election, my lord. This
How
is,
do we know which candidate, what is this post, which candidature? You have not called this into question. According to you, this is correct.
my lord, for this particular, my lord, candidature, what I wanted to say at that time, my lord, that everyone, I am a unanimous candidate, my lord, everyone has supported BJP, AUDF, etc., my lord.
You have not called it into question, Mr. Saikia. You means your.
My lord, my political career has not been even questioned by the writ petitioner also, my lord. And as I have, my lord,
Conclude. The guidelines have been resolved.
yeah. That is my submission, my lord.
This writ petition is filed by the appellant. The writ appeal is filed by the appellant. We agreed with the order dated 25/1/2024 passed by the learned single judge in WPC number 7192/2022. Full stop. By the impugned order, learned single judge has set aside the set aside the appointment of the appellant. Your appointment was set aside, na?
Lordship.
Set aside the appointment of the appellant as president of School Management Committee of Alitangani Osmania Higher Secondary School. The learned single judge has taken into consideration the fact that earlier also the appellant was appointed as president of School Management Committee of which one?
Dogaon AK High School.
Nagaon AK.
Dogaon AK High School.
Nagaon AK High School.
Dogaon
AK High School. However, the said appointment of the appellant was cancelled by the Secretary of Government of Assam Secondary Education while holding that as per the guidelines issued by the state government for constituting SMCs dated 24th of June 2016 and the letter dated 7th December 2016, the appellant is not eligible for appointment on the post of President President of SMC, President of the SMC. It is the SMC and the said order has attained finality. Learned single judge was of the view that when the order dated 3/3/2018 has not been challenged by the appellant, declaring him ineligible for his appointment as president of the SMC, the petitioner, the appointment of the petitioner subsequently on the very same post in another school cannot be sustained. Having heard the learned counsel for the petitioner and after going through, appellant and after going through the material available on record, we don't find any illegality in the view expressed by the learned single judge, hence no interference is called for. Let appeal dismissed.
For hearing, item 49 and 50.
May I, Your Lordship, I may allow to request Mr. my learned counsel to argue his better passport.
You,
Item
you
50.
be allowed to,
I may be allowed to request my senior counsel to argue his case bar.
not allowed. Now, not allowed. No permission.
Both the cases are in Lordship.
What are you saying?
Both the cases are Lordship,
Both the,
same subject matter Lordship. That's why I am. My senior counsel is sitting from long time. Then may I submit to him?
okay.
Sir. Wait, please, Your Lordship.
So the, 50. Dispute regarding the pay scale,
Pay scales, Lordship.
fixation of pay scale.
Pay scales of the paid graduate teachers.
Education tribunal.
Yeah, Lordship.
You can very well raise this, grievance before the education tribunal. It's a service matter regarding pay scale.
Lordship.
Why directly approaching this court, sir?
The Assam Administrative Tribunal is functional.
Yes, yes.
Suppose that.
I've not that from going there. Maybe. Huh? Telling the notification also, Lordship. Provide that the pay scale has been amended. That is our grievance.
Notification is the, ultimately you are seeking relief.
Ultimately, pay scale, that the modification of pay scale you have challenging. Your Lordship suggests that we should go there, we'll go there, no problem in that case.
L. Chandrakumar clarifies, even the notification, except the legislation which creates the tribunal, everything else can be looked into by the tribunal.
Complete your instructions in that effect. Complete your instructions, either to approach the tribunal
Lordship, Lordship.
and be prepared that whether any notification can also be challenged in the tribunal or not.
Lordship.
Let's not ready.
Paragraph 93 of L. Chandrakumar.
Lordship, I'll check. I did legal.
Item 55.
Oblige.
Not ready.
Mr. Sekya, better luck this time.
It's all depend on case to case. The tender condition here says if the highest bidder is deficient in respect of certain documents, except the earnest money and the court fee, In that case, he'll be given 3 days time to make up the deficiencies and to deposit the kiss money, etc., my lord, security, whatever, my lord, within a period of 7 days. So with the first highest bidder, he having withdrawn from the fray, the writ petitioner become the highest bidder. He was deficient in respect of certain documents. He was given a time, my lord, to submit his documents within a period of 3 days. But in spite elapse of, my lord, 7 days, he did not do anything, my lord. Then my lord, the committee again said and cancelled his, my lord, candidature, and it was offered to me. I was also, my lord, deficient in respect of 2-3 documents. So I was given 3 days time and to deposit the kiss money. Within the time, I have submitted the
What is the position at present?
my lord, the respondent is running.
Respondent is running.
Yeah. Writ petition.
My lord, this market was settled only for 1 year, my lord. He has run the market up to December. And then as per honorable court's order, I have deposited the remaining kist money. And my term will be over in the next month, only 30 days remaining. As, yes,
Really, is there any interest in that?
my lord, as
For
per,
a few days, if you are really interested in running that.
My lord, they are therefore preferring the appeal, my lord.
in any
Yes,
case,
my lord, moment, my lord, his offer was cancelled, my lord, his security, etc., earnest money ought to have been forfeited, but
Pursuant to this order, if he has now, he is operating and he has also deposited the money for 15, 20 days or even for month. What more you will get out of it?
my lord,
Complete your instructions. Complete your instructions. Though we are we may take a different view in this matter, learned single judge may be correct or not, we have to decide. But looking to all these facts, you please complete your instructions.
the position is same, my lord, because he also has could run only for a few days, although, my lord, validly he has submitted all the documents, all the things, my lord.
my lord, it
And
is
the
a
only
military
ground
market,
in
my
the
lord.
writ
He has-
petition was that he received the notice on 10th.
That learned single judge has said that is not accepted. We have gone through that.
Lordship, my lord. But
While-
then
while
before his
observing that again, is it
he submitted the application, my lord, this deficient document or the security on 15, whereas on 14th itself,
No, no, 14.
prior that, my lord, it was already settled with me. I have deposited, my lord, the kiss money, etc., and I was running, my lord.
to complete your instructions, ask your client whether he is interested or not. After a week,
Lordship.